This is case number 21-152-641. This is Rochester University, also known as Rochester College versus Chandra Keys. Matters before the court on the issuance of a subpoena. Your appearance for Rochester College, please. Do I have Rochester College on the Zoom? Do I have Chandra Keys on the Zoom? All right, the record should reflect that the matter of subpoena was set on for 9:30 a.m. Neither side appears to have appeared on that matter. Accordingly, the subpoena will be set aside this time. The court now calls case number 21-341-547. This is Motor City Corporation versus King's Customs Incorporated. The matter is before the court on it appears on plaintiff's motion for application of writ of eviction. Your appearance for the plaintiff in this matter, please, Motor City.
Good. That's not me. That's Mr. Mason. I'm sorry.
For Motor City Corporation, your appearance, if you will. And Mr. Mason, you are yet on mute, so if you'll hit *6, and that'll get you off of mute.
Oh, I apologize, Judge. Good morning, Mayor. Please, this honorable court, Lance Mason, P43926, appearing on behalf of the plaintiff and moving party in this matter, Judge.
Thank you, Mr. Mason, and good morning to you. For the defendant, King's Customs Incorporated, your appearance at this time, counsel.
Good morning, Your Honor. Alan Applebaum appearing on behalf of defendant.
All right, thank you, Mr. Applebaum. Your P number, if you will, for the record, sir.
P36444, Your Honor.
Thank you, Mr. Applebaum. Good morning to you. Mr. Mason, tell me what's going on here, sir.
Yes, Your Honor. First, I appreciate the court's indulgence and letting me go first. Even though Your Honorable Clerk, Ms. Hunter, did a great job in sending out notices, Mr. Applebaum indicated this morning, unfortunately, he didn't get a copy of the notice, and I didn't get one as well. So what I will request the court respectfully is just for a 2-week adjournment to allow him the opportunity to talk to his client on this matter, Judge, because I didn't want any technical issues at all. And then there's one other issue, Judge, because the judge has handled this unique case. I'm requesting permission in anticipation of whatever ruling for me to pay the $15 eviction fee, because I wasn't sure in terms of how this case was proceeding, how the court wanted to proceed. So with respect to the adjournment, I'm requesting the adjournment and also the opportunity to go down there today or tomorrow to pay the $15 eviction fee.
All right, first of all, the court will grant leave to meet the requirements as it relates to any eviction fee that may be required. So leave is granted in that regard. As it relates to the other issues, Mr. Applebaum, a simple request for an adjournment for a couple of weeks. That makes sense to you, sir?
Yes, Your Honor. My client has indicated to me that that he was going to seek new counsel. I've had a couple of text messages from him, but no contact since probably early July. So I'm still the lawyer of record. I've never motioned to withdraw. I will keep appearing. I will let him know. But there's not much I can do other than just to let my client know that, you know, there's been a breakdown in our relationship. And he's indicated he wants to get a new lawyer, which is fine with me. He had indicated he was going to file, that new lawyer was going to file maybe a motion for reconsideration or a motion to set aside the order. Apparently that hasn't been done yet because I've never heard from a lawyer to do a substitution, and I didn't. So I'll keep quiet while I'm ahead. And if the court would appreciate the adjournment, I'll let my client know. I'll appear if necessary. If not, if he has a new lawyer by then, we'll deal with it.
Perfect. All right, so I will go ahead and set it over for my next action date. I'm going to be away right in that time to 14 days, so to be a little bit beyond that. Madam Clerk, you will. September 1st. 9/1.
It's fine.
22, and that's going to be at 9:30 a.m. 9/1/22.
Thank you, Your Honor.
All right, and I will hear the issue on the motion at that time. All right, good day to both of you. All the best.
Thank you, Your Honor.
On that
Thank you, Your Honor.
transition. All right.
Thank you.
Good day, Mr. Mason.
Great day.
All right, the court now calls case number 21-173580. This is Tidewater Motor Credit versus Keisha Plummer. The matter is before the court. I believe this was up one time before. I sent it over for the hearing on today's date. I am in receipt of the answer in this matter. Your appearance for the plaintiff, if you will.
Good morning, Your Honor. Jay Lazar on behalf of the plaintiff, P69480.
Thank you, Mr. Lazar, and good morning to you for Keisha Plummer.
Good morning, Your Honor. Cody Brooks, P83108, standing in on behalf of attorney for record Kelsey Sill for Miss Plummer, who is also present by Zoom.
Thank you, counsel. Good to see you, Mr. Brooks, and good morning to you.
Good to see you, Your Honor.
It's been a little while since I've been away from that glorious docket over there. All right.
Yeah, it's running right along though. It's doing okay.
Yeah, it goes to show it's easy for people to just move on once you're gone. Just move right on. Life keeps going. I hope all is well there.
Yes,
All
sir.
right.
Yes, it is.
All right. So what's going on here? Somebody updating. I see an answer filed.
Yes.
Somebody go ahead and update me on things here.
Thank you, Your Honor. So we're asking for discovery to be opened for at least a 60-day period. My understanding is that Ms. Sill has reached out to Mr. Lazar to get some documents, but none have been forthcoming yet. I was updated last week, so if that has changed, I'm not certain.
All right, Mr. Lazar, it makes sense to you, a period of discovery on this case?
Yeah, so my only issue for my client, on behalf of my client, is, and I know Mr. Brooks just mentioned, I don't know what he's referring to as to any requests, but we just want to limit it to documents that have not already been produced and provided, because there's a certain we need to see a little bit of an effort on defendant's counsel to get these documents from their client that they already have. They've already been produced. At least some sort of a good faith effort, and then some letting us know that she even tried before we redo something that's been done already. But again, any request sent to me, I didn't see it. If she wants to send it in writing, that'd be great. I know we get bogged down with emails. I actually, just for the record, reached out to her. She didn't reach out to me. I called her first. And I did mention to her, and Mr. Brooks hopefully can relay to her, call me, don't email me. Emails do get lost. It is much better to fax or mail. And anytime she wants to, ask for something informally, again, when you're on her order something that's different. But I did make wind to her immediately that she's going to have a lot more luck calling than on the email. But regardless of that, plaintiff, as long as plaintiff can get a motion date, we'd be happy to file our motion for summary. It'll include all documents. I will note, to Your Honor and Mr. Brooks, that this was filed with signed contract, affidavit, statement of the purchase. A lot of those documentations were there. So again, I guess I'm going long-winded and I'll cut myself off. I just want to make sure, Your Honor, because we've been down this road with the other side before. We want the discovery to be limited to documentation that has not already been provided.
All right.
Mr.
Brooks, yes, sir.
Yeah, just my understanding is what was requested was a ledger of Miss Plummer's payments that were made, the notice of default, the right of redemption notice, and a deficiency balance statement, as well as any information about the vehicle being sold at auction, including auction notices and advertisement. That was in a May 11th email that Ms. Sill sent to Mr. Lazar.
And again, Your Honor, every single thing mentioned other than a current ledger, which we'd be happy to provide, was properly given to Ms. Plummer previously.
All right, well, certainly those items would be discoverable, given that there are some challenges here. Setting forth a schedule, a formal discovery seems to make sense under these circumstances. Obviously, this court looks with disdain upon abusive discovery tactics that do not comport to the court rules. So I'll address those if they come up, but we have to give everybody a clean sheet to work with. So I'll grant discovery, open discovery for the next 60 days. That date will actually be through the date of your next action when you come before me again. That's going to be
10/12.
that's going to be 10/12. 10/12 is going to be the next action date in this matter. So discovery will be open through that date, and I'll send out an order in that regard. That order will have the date at 9:45. So it will also have paragraph number 6, which allows for the filing of motions dispositive or otherwise, and setting them for hearing on the date of the next hearing. So long as you allow the other party at least 10 days to respond to the motion prior to the hearing date. So you may file a motion, dispositive or otherwise, and set it for hearing on 10/12/22, so long as you give the other party at least 10 days to respond to the motion. So that's, you'll get an order letting you know those kinds of things. That does not mean that you cannot file a motion in the future. But again, sometimes during discovery, parties figure out that, hey, this case should be disposed of this way or the other. And I don't like to go through that period and then you come back and then we set a motion date. So you can set it for hearing on the 12th. All you need to do is make sure the other party has at least 10 days notice prior to the hearing date. All right. And that will all be in written form. Just wanted to call your attention to that on the paragraph number 6 in the order that you'll receive. All right. I wish you well. The date is set, and all the best to both of you. I'll see you at that time.
May I just confirm, Your Honor,
Thank
that was
you.
9:45 a.m. on October 12th?
That's correct, sir.
Thank you very much, Your Honor.
Thank you, everybody. Be safe.
Have a good day.
Thank you.
Thank you. Good day to you.
Well, that's good.
Mr. Weberman, are you there?
Yes, yep, sorry about that.
I think I called your case. Are you on Rochester?
Now I'm on HS Financial.
Oh, that's why you didn't answer.
Yeah,
I don't have, let's see if we have that one.
I had a show cause for 9:30.
Yeah, I see it, but I don't see the file. No.
Okay.
Sorry about that. It's on the list. I just don't have the file in front of me. So just 1 second here, sir. All right, this is case number 21-167-887. Strike that 687 are the last 3. That's 21-167. 687. That's HS Financial Group LLC versus Jania Waller Bay. The matter is set on before the court on a subpoena. I'll strike that previously was set for a hearing on a subpoena, and then there was a petition for a show cause on this matter. Counselor, your appearance, please.
Daniel Weberman, P76609 on behalf of the plaintiff.
All right, thank you, counsel. And you're asking for, let me see if I have Ms. Waller Bay present on the Zoom. It does not look like it. This matter was set on for 9:30 a.m. on today's date. It looks at, 9:30 a.m. All right, counsel, you're asking there that the court would issue a bench warrant in this matter. You may proceed at this time.
That is correct, Your Honor. I request a bench warrant.
All right, very well. The court will grant the application for bench warrant regarding this matter. I'm looking at the judgment amount upon entry at $2,012. That was in 2021. The court will set, I'll strike that the judgment was entered at $2,197.90. The court will set bond on the bench warrant at $2,500. So ordered. And if you'll submit that, counsel, we'll get that right out to you.
All right, thank you, Your Honor. I'll have it sent in. Thank you. Have a good day.
Good day to you as well, sir.
other party is in the hallway, so they're gonna get an officer at 11 o'clock.
Y'all want them to go on Zoom?
Those people. No, they're coming in.
They coming in.
Mhm, yeah. They're gonna get a, oh yeah, we didn't have an officer, so I guess he's gonna get an officer.
Okay.
All right.
Hi, how are you?
All right. Are they okay to come in? You want them to come in?
But you want to come in yet?
Yeah, they can come sit in
Okay,
the
yeah.
courtroom.
mhm.
That's good, Tifa.
That's good, okay.
Mhm. Good morning, Your Honor.
Good morning, how are you?
Okay, how are you?
Good, all is well.
Huh?
Carolyn Carson,
Oh, yeah, she's on the case. Yeah.
she's outside.
Oh, okay, all right.
All right, this is case number 21-160-888. This is Cara Carson versus Oliver Management LLC. The matter is before the court on a continuation of a bench trial. You can come to the forward area here. Yeah, the attorney, counsel, come onto your position, sir, then position your client there, if you will. And if Ms. Carson is present, please make your way forward, ma'am. And Madam Officer, bring Ms. Carson this way and through the door on this end, if you will. There you go. To that door, and she's gonna sit on this side. Counsel, let's see what we can go about extra seating. Yeah, I think so. That's kind of small. Go ahead. Let's see if we can make that adjustment. Yes, you should be on this side now. Thank you, Ms. Carson. All right, thank you. And Madam Officer, yes, come and remove the calendar from that. Have to say here. We'll take that down for now. Okay, just open your hand. Just sit it on. Thank you. Appreciate it. All right. When we were last with this matter, the court reporter is with us by way of Zoom now. Madam Court Reporter, are you able to you're able to pick up on the sounds or okay?
Yeah, so far, Judge, it's fine.
All right, very well. Ma'am, let me have you put your name on the record, please, if you will.
Karen Carson.
All right, thank you, Ms. Carson. Counsel, you may proceed with your appearance. You're gonna have to switch that around, Counsel. I'm gonna need you over there. And Counsel, you're gonna be here, sir.
Well, she's gonna be doing direct
Oh,
examination.
I'm sorry, Counsel.
Yeah. So, Ms. Morford, this
All right,
is
my
our
mistake.
client right here. Would you like my client to sit right here?
I know you're fine. Whichever way you choose, I just need that lead seat to be the person that's going for you. You did it right. Thank you, Counsel. All right, your appearance at this time. Madam
Yes,
Counsel.
good morning, Your Honor, Attorney Jessica Warfield, P85391 on behalf of Oliver Management LLC.
All right, thank you, Ms. Warfield. Counsel, you could enter your appearance if you wish to do so as well. sir.
Yes, Your Honor. For the record, from the class P78607 on behalf of the
All right, thank you, Mr. Potts. All right, so when we broke glass and I elected to bring the parties in, primarily because there was a request by Ms. Carson to have those exhibits admitted that might be consistent with testimony that she offered. And there was objection to the same. The court was of the mind that the testimony that was offered in the case did comport with some of the exhibits and would help the court to better understand the case. And counsel for defendant summarily objected to the plaintiff's petition for admission of various documents. And one of the unfortunate things is that the documents are somewhat voluminous, and there are a number of pictures and things along those lines. Fortunately, the court is sitting as a trier of fact. This is not a situation where there is a jury that is involved. In order to do this, I brought the parties in to try to get through the situation. So, Ms. Carson, if you will come to the podium area, if you will, ma'am, you're standing there in the podium area there. All right, you were asking, and officer, you position either here or on that side. You can move anywhere you want to, but generally your position would be somewhere right here or on that end. But then if you need to move about, everybody else has to keep their position. But if you can walk in front of me or whatever you have to do, okay? All right, very well. So, Ms. Carson, based upon the testimony that you offered, which was somewhat wide reaching in terms of the entire relationship that you had with the defendant Oliver Management. And of course, in your testimony, you specifically indicated that you dealt with various persons that were part of Oliver Management, Miss Oliver, Mr. Oliver. They, of course, have been dismissed out of the suit, but the suit remains as it relates to Oliver Management. There are a number of documents that you have submitted to the court, both by way of a series of text messages. You also submitted a number of different photographs. You submitted inspection reports, and you also submitted a ledger history with documents that you generally submitted to the court. You submitted a letter from the Attorney General's office. You submitted a engineering inspection reports from the city of Detroit. And you're asking that the court admit those documents. Is that correct?
Yeah.
And you want the court to admit that based upon the testimony that you gave. Is that correct?
Yeah.
I'm going to give these to the officer to bring to you, ma'am. I want you to take a moment to go through those documents and tell me if among those documents, you can sit down and go through them. I'll give you a moment. If among those documents, there are items that you say, well, Judge, I don't think that one needs to be admitted. If you see something in there that you think, as you go through, if you see something in there that you believe would not help with this, or is not something that should be admitted, then tell me that. Or just pull it out, separate it out, and then we'll talk about it. If after going through it again, you believe that everything that's there should be admitted, then you tell me that. But if you see something that you say, Judge, you don't need to see this one doesn't contribute to anything, then let's start there. The next step is going to be, of course, whether or not the documents that you wish to admit are consistent with testimony offered in regard to this matter. Also, I want to send to you as well other items that you sent. Just take a look at it. There's no pressure. I want you to look at it. If you see something that you believe should not be admitted to the court, or you don't think it's necessary, then let me know that, and just take a moment to go through it. And of course, counsel, what we're going towards is anything that she believes should be admitted, and those items will be placed in your hands for you to go through it and state with any particularity objections that you have. I know that you have a summary objection to all documents, but the court is going to require that you drill down, because I believe that some of these documents may very well be admitted. These may be duplications, but I'm going to send them out anyway so that you can go through them, and then we'll take the next step. Yes, thank you. Thank you all. All right, and council, for defendants, I've received that a number of documents that I'm going to send over to you. These are the documents that the plaintiff believes should rightfully come in based upon testimony as previously offered. Would you take a look at that? I haven't marked anything, but at some point that would become a necessary part of the process. But if you go take a look at those items.
Yes. Your Honor, the ones that we may have an objection to, would you like me to retain those, and present them once?
Or just put them in a separate package.
Okay.
And then we'll try and go through what they are.
Okay.
And of course, the record record reflects that there is a general objection to the admission of documents. That is already noted. This process is brought on by the fact that the court, after listening to the testimony, understanding that there were some documents that the court is of the firm belief that there was some testimony that supports the admission of some of the documents, and that's why the court required this process. The objection one? Yes. All right. The first instance, there are 47 photographs depicting various events that relate to the interior and exterior of the home that reportedly relates to conditions of disrepair, and also that relates to conditions where it appears that someone is making repairs, etc. Ms. Carson, does these photographs in fact accurately depict the various conditions and situations at the time the photograph was taken? Does it actually describe what in fact was occurring?
Yeah, that's.
I'm not able to hear you now. You said that's before.
Before any, before anything got touched.
All right, before repairs were made, you're saying before changes were made. In some of the photographs, it looks like there's someone on a ladder reaching towards.
Eugene Knight, the man that, Eugene Knight, the man in the text messages that they hired, that's him.
All right.
And some of them turns out for lead and start fixing it inside of the house.
All right. So I guess my point that I'm getting at is that some of the photographs show someone at various times doing something. It looks like attempting to, or in fact, making some type of repair or something, correct?
Well,
somebody was working on something.
yeah, I'm just gonna say working on it.
Okay. Got it. Given that your testimony under oath is that these accurately depict the conditions described in the photograph, I will admit those, and I'm going to admit them as plaintiffs two with items 1 through 47. And, if the photographs have to be referred to with particularity, then we'll address that at that time. But generally speaking, the photographs are referred to as packet number 2 or exhibit number 2. And in that packet is 47 photographs. The exhibit number 1 will be the lease agreement in this matter, together with there are two documents that have been talked about by the plaintiff in this matter, and both of them should indicate that they are lease documents that she had some involvement with. The court will admit those as item number 1. Obviously, the admissibility, any issues on objection to admissibility would go to the weight to be given to those documents rather than their admissibility. Clearly, the parties entered into some type of written agreement, and disputes about what the nature of that is exist. And so the court will admit anything that relates to the agreement between the parties. And then, of course, the parties can argue out as to what the actual agreement is. But there was a written document. I will receive that. That will be number 1. All right. Now, I have also in the packet where there is not a dispute other than the general objection that was raised to the admission of any documents. I have a document that says City of Detroit approved third-party residential inspection. That document just appears to be a document that just lists possible places where that could be called for inspection. That's what that seems to indicate. It says Detroit Inspection Group, and I believe that that is marked out. Is that the company that you hired or that you called upon?
No, Your Honor, they said that she hired third party inspection.
All right, gotcha. All right, so I will admit the list of locations or list of inspectors as exhibit number 3. Exhibit number 3, that document will be admitted where there's no objection other than the general objection. Then there are a number of exchanges between the parties in the nature of text messages, and those text messages occur over a relatively significant period of time. I'm looking at text messages that relate to the period of July 2000 20 through December 2020. Then there is another package that also relates to that period, August through October. And then there are exchanges that occurred between the parties. Looks like I'm looking at February, and these appear to be items that relate to 20, like they're 2021, although I don't see that mark. And there are other items that relate to August, September, October of 2020. So a number of text messages. These you testified that there were text messages, that there were exchanges between the parties, and that you were notifying and having information exchanged by way of text messages. Is that correct, ma'am?
Yes.
And these items accurately depict the text messaging that you engaged in, that was directed towards you, that you were able to gather. Is that correct, ma'am?
Yes.
All right, I'll admit the package that is called the text messaging as item number 4. And if there's any particularities that are raised as related to item number 4, then we will address them with particularity at that time. So the text messages will be item number 4. All right, then there is items that again, without objection, there is a property management inspection report that is dated in it looks to be dated in June of 22. Well, it's hard to tell what date this document is, but because the way it's styled, it says 22 June. Then it looks like 20. So I'm not able to specifically know when any action may have been taken in that regard. So I'll come back to that in just a moment. All right. So, and then the final document with which there is not a strenuous objection at this time is a document directed to Ms. Carson from the State Attorney General's office. And that document has contained correspondence that relate to document that has an undersignature by Evelyn Oliver. So it looks like a letter that was written to Ms. Carson, undersigned by Mr. Chad Canfield. It looks further like a letter directed to Mr. Canfield and undersigned by Ms. Oliver. And I will admit that a package of letter exchanges. Where am I at now with exhibits, Madam Clerk? Madam Court Clerk.
5. This should be 5, Judge.
All right, this will be item number 5. So I'm going to send this City of Detroit Building Safety Engineering document, and I'm going to see, Ms. Carson, can you tell me what date that is at the top there? Are you aware when they may have come out in that regard? July 22nd, that would have been what year? 2020. I kind of figured as much, because what it looks like is that it looks like it says 20 in one place and it says 22 in another place. One of them has to be the date and one of them has to be the year. It looks like it looks like the case, it's unlikely that, the year is 22. So, I will conclude that the year on this is 21, given that that is the reflection of the plaintiff in this matter. Moreover, this case relates in significant ways to 2020.
2020, you're right. I think you said 2021.
Did I say 21? Yes, sir. And, so, but this looks like it relates to 20, the year 2020. All right, so I'll admit this document where not strenuous objection. Now identify this document as item or exhibit number 6 for purposes of reference in this regard. Now, there were other
Judge, I'm sorry.
items that-
Judge, I'm sorry, but what is Exhibit 6 called?
Exhibit 6 is called a City of Detroit Property Maintenance Inspection Report.
Okay, all right, thank you.
It is a one-page document, at least as I've received it. I've only received one page. I don't know if there was more than that. That's what we see. Now, as relates to other items that have been submitted to me for proposed admission by the plaintiff. First, I want to address photographs that were offered. And these photographs tend to show at least 2 of them. And I should say that there are a total of 3 photographs upon which objections to admission have been submitted to the court. 2 of them seem to be the same photograph from different angles related to some type of product in some type of containers. And it seems that this is in yet another container. Can you, I'm going to hand those to you, ma'am. In fact, I'm going to hand these 3 items to you, 3 photographs. I want you to tell me what that is.
In the dumpster is when she charged the mold on April Fools.
Okay, take the mask down.
On April Fools 2020, this is what she sprayed out that she took on the mold, stuff for the target mold. So she bought a dumpster to basically put us out, but that didn't work. So she ended up going on it did the mold. And this is what they sprayed afterwards in the house. So right.
All right.
But I once did throw it in the dumpster. I was like, well, I'm gonna pick it up because I'm trying to figure out what it is.
All right, so you would like to offer it to the court simply to show containers that you saw in the dumpster, correct?
Yes.
Moreover, your testimony is that the home was sprayed for mold at some point. Is that correct?
Yes.
And you believe that those, you listening to me? Listening to me? You believe that those containers that was inside the dumpster are the containers that were used for the spraying of against the mold condition, correct?
Yes.
All right, counsel.
That was the clarification, Your Honor, no objection.
All right. I will go ahead and admit these documents. And the testimony is what the testimony is there was a spraying, and so I'll admit the documents for the purpose that they have been submitted to the court, and that will be number 7, containing 3 photographs. Now, the other items that are contained in the package for which there is objection 1 is a ledger history. It looks like this was this something, directing my attention to either counsel, was this something that was drawn up by the, oh, no, I see what it is now. This is a ledger history for storage of items. I think. I thought this might have been a ledger history of the relationship, but this looks like something that relationship claims and storage, correct?
Yes, Your Honor.
All right, so they're objecting. Thank you. I thought I was going to ask you why you're objecting to your credit ledger or your payment ledger, but I see why you're objecting now. Okay, now, so this they're objecting to this to this document. Why do you believe that this document should be admitted?
Your Honor, I never got a chance to put, some of my stuff out of the house, out of storage into the house, so I just kept the storage, because I had it storage before I moved in. So I was, as I first put my first set of stuff down, I'm like, oh, no, because I don't have no money for that, so I kept the storage and left my stuff in it. So the stuff that was in the house, I could throw it out, I don't care about that, but my stuff that I really liked that, I didn't want it in there because it was so moldy that you could smell, it was
All right.
so-
So, all right, I know that you testified that there were some items in storage. So you're saying that these were items that you had in storage before you moved in?
And they still in there now,
They're still in there now?
yeah. I had to put it back in
Yes, Your Honor, so our objection would be that this shouldn't be admissible. It's irrelevant as to claims presented. In addition, Your Honor, these can't contribute to any damages that she's claiming. She had this storage unit before she moved in. She still has it now. It's not a consequence. Her putting these items in storage is not a consequence of whatever happened to the subject property. So we're just, we're objecting to its relevance and admissibility.
Anything else you seem like you had some?
No, that was it then.
Well, again, this appears to be a document that may have some relevance, given that there is a claim that items were unable to be moved out of storage or had to be placed in storage because of conditions on the premises. The document does not provide any specificity in that regard as to what is what. Those are one of the kind of challenges that goes to the weight to be given to that rather than to its admissibility. So I don't know how much this document would help if there is an award of damages, but given that there has been a claim that has been made relative to storage of items, I'll allow the document in. I'll allow the document in as the next exhibit in this matter. But again, that's because the document appears to be admissible. The issues go to what weight the court is to give to that. And the document is not in any significant ways self-defining and things along those lines. So again, with some hesitation, I will admit the document because I think that it is there is some evidence that touches upon a claim that that additional storage was necessary as a result of a claim of conditions upon the premises. For that reason, I will allow the document. I will allow the document. Madam Clerk, what number am I now? Madam Court.
8, Judge. I know you mean me. 8.
Thank you. Thank you.
You're welcome. And can you just tell me what you're calling it?
It's a 3-page ledger history that relates to storage that was maintained by the plaintiff.
Okay, thanks.
There is an incident report that has been objected to here. And this incident report seems to be what was testified about when this defendant, the plaintiff, Ms. Carson, indicated that she believed that her signature had been forged on a document and that she filed an incident report in that regard with the Detroit Police Department. And she submitted this document, which appears to be a 4-page document. Counsel, your objection in this regard.
So just an objection to that, one incident reported in this hearsay, Your Honor. In addition, the timeline on that just doesn't quite make sense. I believe she moved in April 2020. I believe the report from March 2021, if I'm not mistaken. And like I said, Your Honor, it's inadmissible hearsay. I don't believe it's relevant. We have her testimony about lease. I just don't think that's relevant or admissible.
Yeah, I think that the testimony is what the testimony is. And this is basically a potential repetition of that with items that may be contained therein that are of a hearsay nature. What's on this record is the testimony that Ms. Carson believes that one of the lease documents was signed by someone other than herself. And she also testified that she filed a report with law enforcement indicating that she felt that someone forced her signature. That testimony is on this record. I don't see how this document aids in that at all. So I will sustain the objection in terms of the submission on the basis of hearsay.
Thank you.
The other items that are here are residential building inspection that contains a number of photographic support relative to claim of residential inspection conditions. And it looks like there are three. Looks like there may be three reports, or that that these packages contain one report over a period of time. Not sure, but they are. Well, I see written on one document says something about a third inspection. Your basis for objecting in regard to these matters?
Your Honor, the basis for this objection is more so for clarification. I just want the court to notice that on the pictures for both of the inspections, the one dated September 2020, includes a picture of the property with the new roof on it. The one dated,
Okay, slow down.
I'm sorry.
Yeah, okay.
Okay, that's right.
Okay.
The inspection dated September 2020 has a picture of the home that clearly shows a new roof on it. The inspection dated May 13th, 2021 has a picture of the property before the roof was placed on it. So we just wanted to provide that clarity, showing that the roof was replaced. You can see that with that September 2020.
Yeah, I mean, clearly, there's something incredibly different on these two. And what I guess what you're saying is that there's something about the dates because a later photograph seemed to show the roof needing to be replaced, while the earlier one shows the roof already.
Correct, Your
Honor. So, ma'am, the roof was replaced. Is that correct?
Yeah, the roof wasn't replaced, but the man did the same, guy did the same photograph, so I guess he just did it that way, but I can have him to print out something that dates on
Well,
it.
here's what I'm getting. So what you're saying is that whoever was involved in doing repairs, that they ran this photograph from something other than coming out and taking the picture.
No, the guy that did the inspection, it's the same guy that did the inspection. So when he came out the second time, he mustn't have taken no picture of the roof or whatever. He took the picture of the inside, but he already had that picture of the roof on there, so I guess he just took that. But if I go to him, but at the bottom he said, did he fairly just for me? So he did it both times. He came out the day after the city came out, he came out September 2002.
Okay, but for sure, by September 2020, the roof was already on.
She did the roof like after August. So yeah, I think the roof was on by then.
Okay.
But the man that took the picture, he already had the picture of the roof off. So when he came out, he didn't take the picture of the roof the second time. He must have used the picture he already had.
All right. So there's no question about it that there was a roof on this property long before 2021, correct?
Yes.
Okay.
The first time, but I'm not control of what he put on the thing. He just did the report.
Yeah, gotcha. But I understand that. I'm not talking about that part. I'm talking about is what you know. And what you know is that the roof that was replaced, that was done in 2020, correct?
Yeah, the roof was done in 2020. He just probably used it.
Well, you don't have to tell me the other part. So here's what I'm getting from you. Notwithstanding what the photographs may show, you're making it clear to me that with these exhibits that you're offering, that that any photograph that would in any way suggest that the roof was not repaired in 2021, that photograph would be incorrect, correct, ma'am?
Yes.
All right, with that, I will allow the reports to be admitted on this record. And the items that would be raised in relationship to these reports will go to the weight to be given rather than its admissibility. One critical issue has been cleared up, and that is that the any roof replacement was done in 2020, notwithstanding any notation showing a roof being replacement with a date in 2021. So with that clarification, I'm receiving the reports, and they will be styled as contained within exhibit number 9. It looks like there are 2 inspection reports, and those reports are exhibit number 9. The company is called After Our Home Inspections. The reports are called Residential Building Inspection Report. And those items are admitted at this time. All right, that clears up the items that would be admitted on this record at this time. Anything else you wanted to bring to my attention? You have at this point, I believe you rested your case, or you are preparing to rest your case, but you wanted to make sure that you got your exhibits in before going there. Anything else you want to bring to my attention? No, I'm not admitting that document. All right. At this time, then, you rest your case. Is that correct, ma'am?
Yes, sir.
All right. The plaintiff having rested at this time, counsel, you may proceed, please.
Yes, Your Honor, at this time, I would like to make a motion for a directed verdict.
Yes, go ahead and while you're there, yeah, thank you. That helps us a little bit. Thank you.
According to Michigan Court Rule 2.516, a party may move for a directed verdict at the close of evidence offered by any opponent. The motion must state specific grounds in support of the motion, and if the motion is not granted, the moving party may offer evidence without having reserved the right to do so, as if the motion had not been made. A motion for a directed verdict that is not granted is not a waiver of trial by jury, even though all parties to action may move for directed verdicts. Your Honor, here in this manner, even reviewing the evidence and the light most favorable to the plaintiff has not established her claim, Your Honor. Plaintiff's complaint contains claims from mental anguish, from negligence, fraud, and inhabitable conditions. Your Honor, there has been no proof placed on the record that the living conditions of the subject property were so egregious that the property was uninhabitable. In fact, Your Honor, by plaintiff's own testimony rendered on record, she lived in the subject property from approximately April 2019 to August 2021. By plaintiff's own testimony, she stopped paying rent at the subject property in July of 2020 and did not vacate the property until August of 2021. That's a period of 13 months where defendant did not collect any rent for the subject property. In addition, Your Honor, plaintiff admitted that when she took possession of the property, it was in good condition. She testified that in the month of June, she contacted the defendant about a problem, and the problem was addressed, was the flooding. While there was testimony that there was a lingering flooding problems, plaintiff was specifically asked what damages she suffered, and plaintiff testified about a television, although providing no proof, furniture, although providing no proof, and a washer and dryer, although providing no proof. Your Honor, their pictures that have been admitted do not include any pictures of the said television, said furniture set, or the said washer and dryer that plaintiff is claiming damages on. Your Honor, plaintiff is at the close of her proofs and has not established the elements of negligence or constructive eviction, as plaintiff never left the property doing any of these issues that she complained of. Additionally, Your Honor, plaintiff testified that in September 2019, October 2019, she didn't complain of any problems, although the lease instructs the tenant to inform the landlord of any issues. Whether the problem came back or there were no complaints established for at least 2 months, and throughout plaintiff's entire testimony, there was no monetary amount put on any of her damages, Your Honor. As such, even viewing the evidence in favor of the plaintiff, defendant is entitled to a directed verdict at this time.
All right, thank you, counsel. Ma'am, you get the opportunity to respond to the motion for a directed verdict. At this point, the court would is required to review the evidence in the light most favorable to you, and then make a decision as to whether or not there is enough evidence for your case to go forward to the next stage. If there is not enough evidence, then the court is to make the decision as such, and then that would mean that the case would be dismissed. If there is enough evidence to go get beyond this point, then the case would move to the next stage, and the defendant would move forward with whatever presentation they wish to make to the court. So you can come to the podium and tell me why you believe that there is enough to show that you're entitled to damages in this case at this time.
Okay, Your Honor, first of all, it is like a nightmare on Elm Street. So conflict happened. I'm not gonna have a picture of the team, and I'm not gonna have a picture of furniture, blood, all the problems on an everyday basis. Me and my mom went through a lot, and now I literally lost my mom in the process. We were sick the whole time. Yes, we was trying to move, but it was the middle of pandemic and corona. So at the end of the day, it was hard to move. I'm still in a position right now until today. So at the end of the day, it's like it was so much happening, so much going on, so much loss, and so much we had to clean up today. You would have to be in my shoes to even understand like the length of the time and everything. And yes, once again, Your Honor, I'm trying still to today to find me somewhere comfortable so I can just lay down and have a good night's sleep today because of this situation. And I feel like if you have a property and it's not maintenance, don't rent it out to people. You never know how you change people's lives out. So at the end of the day, I've been through the storm and the rain. I didn't care about me getting sick, and I still don't care today. But my mom was getting sick in the process. She knew that. I'm telling her that she knew the situation of the house. But instead, it seemed like it got worse instead of better. So yes, I have I have stuff that I bought that I'm not gonna keep over there, you see, because I'm trying to keep stuff clean. I'm trying to keep this. I bought so much for the mold smell, keeping stuff down, washing, cleaning, having people to help me. I'm not gonna have those receipts of somebody I just call and say, can you come over here and help me? So you're not gonna have those receipts. There's a lot of stuff you're not gonna have because you're trying to survive life. And this right here, I just pray to God that I survive. I hate that my mama had to leave in the process of us going through this situation. But at the end of the day, I'm still standing here to represent that we went through a lot just to live somewhere that we could have just, I wish that I would have just changed the time about the situation, but it's more than enough evidence in there to let you know that something occurred. I don't know what they want you to say or to do, but it occurred. It's I mean, there's nothing more to say because I just don't know what to say at this moment, Your Honor. So I mean, receipts and stuff I have in storage. If I can go dig through there, since my mom that I haven't looked through her stuff or looked through the storage. So I really at this moment didn't care about life at all. Like my birthday just came up. My whole plan of it's like if I had to live like this another year, I wouldn't even make it to court. It's just the support and the family that I have driving me through it just to stay afloat. So at the end of the day, Your Honor, it's more than just what you go through, it's why and how and how much longer did I would have had to go through. Yes, I stayed there after those months, but by me having to just try to keep it clean, leave it, I mean, you know, just even with the blood and every day, the electric, and this was the everyday problem. So I took it upon myself since I didn't have nowhere else to go. I started having people to help me. Can you help me? Can you help me, please? So I don't know what else to present to let them know that, you know, that it's a situation that she could have avoided too, because if you're a management company, you shouldn't have all those things going on with your house that you it was the process of, well, yeah, I mean, that's all I can say.
All right, thank you, ma'am. Madam Counsel, you got the last word on your motion, if you will.
Yes, Your Honor, very briefly. First and foremost, as we have stated again, deepest condolences for the loss of this person. We sincerely mean that. In regards to the proofs that have been submitted, Your Honor, no evidence has been given regarding medical records, showing that the condition of the property is what made Ms. Carson and her mother sick as she claimed. Regarding even the proofs that have been presented shows that action was taken on the property once our client was made aware of it. You saw the pictures of people in there fixing and cleaning. You saw the fact that a roof was repaired, Your Honor. So again, just at this time, the plaintiff has not been able to provide proofs to support her claims. We are asking for the record at this time.
All right, thank you, Counsel. All right, the court has listened to the testimony offered in this matter, and notes that under the appropriate rule that the court on a motion for a directed verdict, sitting as a trier of fact, has to view the evidence in a light most favorable to the non-movement, that is to the plaintiff, and determine whether or not a rational trier of fact could conclude that the essential elements of the claim presented before the court have been proven, again, with the evidence viewed in a light most favorable to the non-movement. In this case, as in any case, the proof of damages with some degree of specificity is one of the requirements under the court rules and under the statutes regarding an award of damages. This case arises out of a landlord-tenant relationship, and so the statutes regarding landlord-tenant relationships and condition of residential premises become a relevant consideration in looking at this kind of case, because that is the law that governs this kind of case. The testimony offered by the plaintiff as the only witness in this matter, together with the exhibits that have been offered, would tend to show, if I view the case in a light most favorable to Ms. Carson, would tend to show that she occupied the property for a significant period of time, as articulated by Madam Counsel on this record. And over that period of time, she made considerable complaints. But notwithstanding the complaints that were made, the evidence that is presented by the documents submitted to the court in testimony of Ms. Carson is that there were repairs that were made over time, that all of this occurred during the period of the COVID, the high point of the COVID virus, if you will, and where there were spikes and et cetera, et cetera. And the testimony of Ms. Carson is that during that period of time, she sustained substantial damage by there being a substantial material interference with the habitability of the unit. Under the statute where such a case exists, that essentially results in what is referred to as constructive eviction. Now, some of this may be as a matter of, and again, viewing in the light most favorable to the non-movement, some of this may be a result of the adverse impact that the limitations of the COVID environment impose upon the landowners as well as upon tenants. But you end up in a situation where both sides end up being in a bed that's uncomfortable. The tenant is occupying a property where there is persistent water backup, water damage to the property, as well as other conditions that she's testified to regarding electrical problems on the unit, the loss of furnishings, and other complaints that have been raised, and those are validated by the inspection reports that have been they're validated by the various photographs that have been submitted to the court, showing that there are conditions on and about the premises that substantial material interfere with reasonable habitability. You cannot support a notion that a premises is habitable just because a person continues to occupy. People continue to occupy property for a number of different reasons. That's why the statute requires that we look at whether or not the reasonable habitability of the unit has been diminished. And to the extent that that has occurred, that could in fact result in a conclusion that the defendant has been constructively evicted or has been prevented from occupying property that is reasonably suited for occupation or for being occupied, I should say. And all of those are questions that there has been some evidence offered on by the plaintiff in this matter. And the statute allows for some proof or some ability to prove damages with specificity in this case, because the statute sets forth an amount that the court can use as a way of calculating the diminution or the loss of value in the occupation of the unit. The fact that there was rent that was not paid, withheld, and that the tenancy was not, in fact, ended is secondary to a couple of things. One, again, the pandemic. Secondly, that there was a situation where the property was in a state of disrepair. These are issues that are relevant issues in this case, and these are issues that have been put forth by the plaintiff in her direct testimony to the court and over cross-examination. I mean, the case, what it looks like to me at this point, again, viewing the evidence in a light most favorable to the plaintiff, as I have to do at this point, the case looks like it is what it is. That this turned out to be a pretty bad and disastrous situation for all parties involved. The rental of the unit, it appears from the testimony of Ms. Carson, that upon occupying the unit, that she felt that things were okay, that she felt it was a pretty good state of repair, although she felt that there were some things that were going on, but that nothing was major. And then the problems started arising after she moved into the property. And I don't believe for one moment, and it's not really important what I believe, but at least based upon what the testimony is here, I don't believe for a moment, and I'll articulate it that way, that this agency or its owners said, well, we have a place that's going to flood, let's put a tenant in there. I don't think that the evidence support that. That's why I say that it was the convergence of it seemed to be the convergence of a perfect storm. You have a situation where you have people at arm's length trying to rent a property, the person trying to, people trying to lease it, and another person trying to occupy the property. And lo and behold, they began occupying the property at every kind of problem that you could imagine that is secondary to flooding, persistent water coming up in the property, some electrical problems begins to occur in the property. And lo and behold, right in the middle of that, you have the pandemic. You have limitations on being able to get workers and people going to homes and so on. So that's in some sense that's a perfect storm. But the case is what it is, at least at this point. I haven't heard the other side of it, but if I look at the one side of it, and I look at the pictures, the photographs, I hear the testimony, I see that there was an attempt to mitigate a mold type situation. I see that there was a city inspection. I see that there were other inspections that depicted conditions throughout the premises. It looks like there was enough going on there to diminish the quality of life and relationships of living in the property. And that would be compensable. Even if I consider this case, obviously the issue of infliction of emotional distress, that is a real high burden to me. And I don't think that in this case, that the burden of meeting the standard of infliction of emotional distress, either intentionally or negligently, I don't think that is met under the circumstances of this case, although I'm convinced that this has been painful and distressing to Ms. Carson, to her mother, but from a legal standpoint, how you arrive at a situation where you can receive damages for emotional distress, that's a very, very high standard. And there's clearly not enough evidence in this case to meet that standard. Not meeting that standard does not mean that a person did not suffer distress. Ms. Carson has testified to distress that her mother suffered, to how difficult it was to live within the unit. But intentional or negligent infliction of emotional distress requires more than that. It requires a situation that's basically tantamount to a person being in a premises and suffering a asthmatic condition in the middle of that situation. The landowner knowing about it, knowing that that person has been taken to hospital, and there is a diagnosis that says that they suffered this condition because of the mold or some other condition in the property, and they're going to be coming back, and lo and behold, you better remove that before they come back into the house. and you know that they're coming back, and you don't remove it. Now you're getting into the territory of intentional or negligent infliction of emotional distress. That's how high the statute sets the requirement to meet that particular burden. And there's not enough evidence in this case to meet that burden. It's just not there. Even if I view it in a light most favorable to the plaintiff, and even with all deferences to the plaintiff, knowing that she suffered emotionally regarding some stuff there, and her mother may have suffered emotionally regarding some stuff there, and she's suffering now because of the transition of her mother. Certainly, there is no proof on this record that her mother's death was secondary to any conditions on the premises and so on and so forth. There's not that there. Otherwise, I suspect that this would be a case in circuit court sounding in wrongful death or something along that line. No, ma'am, no, there's not enough proof on this record for those type items. And so I will grant the request for the record verdict on the claim of emotional distress under the statute. The impact that this has on the tenant, from when I view it in a light most favorable to the tenant, relates to having to occupy premises over a substantial period of time that the conditions of which unreasonably interfered with reasonable habitation. That is kind of the heart and center of what this case is about. Also, this case remains relative to the claim of damages that can be reasonably calculated as to whether or not there was loss of items of furnishing, loss of television, loss of items of furnishing, where the court could make reasonable calculations as to what the reasonable value of such items may have been. So those are items that remain on this record. Otherwise, the motion is granted in part, denied in part, and the case would proceed accordingly. So ordered. All right, and when you're ready, the case is to the bench now.
Your Honor, at this time, I would like to call in the witness, Ms. Elvin Oliver.
All right, thank you, Counsel. You may at this time.
She's staying right here, Your Honor, or?
Does she have any mobility problems at all?
I do that, but I'll be fine.
Okay, come and we're gonna have you come do this for me, ma'am. Watch the officer. Officer, bring her around this way, if you will. All right, and let me have you right here, Madam Officer. Let me have you reach right in this one at this time. You do solemnly swear or affirm that the testimony you're about to give is the truth, so help you God.
I do, Your Honor.
All right, and state your name for the record.
Evelyn Oliver.
All right, thank you, Ms. Oliver. You may step right in now, couple there, and then have a seat once you. Thank you, Ms. Oliver. Thank you, Officer. And you may proceed at this time, Madam Counsel.
Thank you, Your Honor. Ms. Oliver, can you please state your name for the record?
Evelyn Oliver.
Thank you. And Ms. Oliver, what is your affiliation with the defendant in this matter, Oliver Management LLC?
She was a tenant in one of our properties.
No, what is your, I'm sorry, let me repeat the question. What is your affiliation with Oliver Management LLC?
I am one of the principals.
I'm going to just start in regards to the facts of this case. Ms. Oliver, can you please say, do you know the plaintiff, Ms. Carson?
Yes.
How did you meet Ms. Carson?
Somewhere around the end of March of 2019, my sister-in-law contacted me and said that she had a friend that was living in a hotel and they needed a place to stay. And I asked her, why were they living in a hotel? And she said, well, she didn't know. So I just kind of didn't feel good about it. And in April of 2019, Kara Carson emailed and texted me and identified who she was and told me that she really needed a place to stay. And I do have text records of that conversation. I have the entire text record of the conversations we had from that time forward. So she's not texting me.
Okay, Ms. Oliver, so let's start at that initial lunch text message with the plaintiff texted you asking to rent the property. What month did that happen?
It was early April 2019.
Okay, so when you had this conversation, did you allow Ms. Carson to view the property beforehand, or what was the conversation like? When was she supposed to move in?
She told me that she was really looking for a place. She didn't care what place she was looking at. In my family, I'm the go-to person, and I had my sister, my brother, and other relatives live there. Tenant had just left the premises, and I hadn't had an opportunity to go there. So when I got her text message, I agreed to meet with her. And when she came and looked at the premises, what needed to be done was the tenant that left before left a lot of clothing and items in the house. Ms. Carson agreed that she would, I agreed to Ms. Carson. She said, well, I can fix this up. I can clean it up because there were clothes and articles that the tenant had left. So I told her that I would charge her the low market rent, $600 a month, and I would give her, only charge her $300 a month for security, or $3,300 for security. So she paid me $900 for the first month rent and security.
When did she remit that payment?
She made the payment April 6, 2019. I took it to Oliver Management LLC Bank, and I sent Ms. Carson a receipt for the payment.
Now, was the lease agreement entered into on that same date as
Yes, it
well?
was.
Your Honor, if I could, I would like to draw attention to Exhibit 1, lease agreement that has been entered.
You may have to sign up.
Thank you. Now, Ms. Oliver, do you remember the terms of the lease agreement? For example, I think you already mentioned it. How much was Ms. Carson supposed to pay?
$600 per month.
Okay. And do you know how she was supposed to get tender this payment?
I do not accept cash. I asked her, and in the lease, I put in our LLC account number, and I told her she was supposed to make deposits directly to that account number. And I have copies of receipts where she did in fact do that for the times that she did pre-rent.
Now, in regards to this rental agreement, was there any type of provision where the tenant had to sign off on the property or acknowledge the condition of the property before moving
Yes.
in? What was that condition?
The condition was that she was fine with the property. And the
How did
property,
she acknowledge that?
she signed the lease. She looked at the property. Her girlfriend came with her to look at the property, and they kept walking through it, and the property was in good condition, except that there were a lot of clothes scattered around the house, and she agreed to move those, and she agreed to paint the property.
Now, in regards to Ms. Carson's responsibilities in regards to that property, according to the rental agreement, what were her responsibilities?
Her responsibility was to notify me of any problems or issues with the house. And the first notification she gave me of a problem with the
Hold on a
house.
second, ma'am.
I'm sorry.
You answered her question, your next question.
Oh, I'm sorry. Thank you. Now, when she did move in, was this like on an emergency basis, or
Yes,
was it a gradual move-in?
she said that they needed a place because they were living in a hotel. They needed a place to stay. And that's confirmed in the text message.
Okay, Ms. Oliver, so I'm gonna ask you, were you the main one in communication with Ms. Carson regarding the subject property?
Yes.
Okay. Now, just gonna dive right into it. When was the first time you were notified about any defect on the property?
It probably was a few months later. She notified me and said that the basement was flooding. And I tried to call several contractors.
I'm sorry, I don't mean to cut you off, but when you said she notified you, who did
She
she?
texted me, Kara texted me and told me that there were some problems with flooding. And it had been rained in Detroit for a while. So I contacted several contractors, and I texted her and I said, did a contractor contact you back? To me, when a tenant makes me aware of an issue, I act on it right away.
So so you said that you contacted different contractors.
And I kept in communication with Kara. And at one point I texted her, I said, did this specific contractor contact you? And she says, well, somebody contacted me, maybe I'll talk to them tomorrow. I kept texting her, inquiring about what is the status of this. finally, she contacted me by phone and told me that she knew somebody that could fix the situation, because it was hard to get a contract.
How long after she first reported the flooding was there someone established who could remedy the problem?
I'm not sure it was, I know I started on right away. You can see that in text messages.
Do you, okay. So someone ended up being hired to fix the.
She
issue.
told
Do
me
you
that she
remember
knew
who
a
the-
man.
okay,
Yeah,
hold on one
second,
second,
hold on
hold on
one
one
second.
second, Sullivan.
Right.
Do you remember who this person was?
Louis McVeigh.
Louis McVeigh. And was this someone you knew or someone?
It was someone Kara knew. And what she said to me in the phone, she says, well, you're trying to hire professional people. I know somebody that could do this. Now, I generally hesitate from doing that because, but we have been trying to get a contractor out there. I figured, well, let's go with someone she knows so we can fix the problem. My objective was to fix the problem.
Okay.
So Mr. McVeigh contacted me and told me that he would pay me, it would cost $1,100 to do the job. And I said,
And what was the job? Ms.
and
Sullivan?
that was to dig up the basement to fix the issue.
What was the issue?
The issue was that there was something wrong with the drain, and he had to dig it up, and he had to go out, he had to dig it up, and he charged me $1,100. He said it would be cash. I told him I don't really carry cash. I didn't like the idea, but because I was trying to get it done and it was somebody she knew, I went with him. And on the receipt, which I have a copy of, he said 6-year warranty.
A 6-year warranty on the work that he did.
On the work that he
Okay.
did.
Now, let me ask you this, the flooding that occurred in the basement, did it impact any other area? of the
No.
home?
No, it did not.
It was only in the basement?
Only in the basement. And that was the first time she had ever notified me of an issue, and I took care of it immediately.
Now, when Ms. Carson, reached out to you about the flooding in the basement, did she mention anything about any of her property being damaged, or
No, she did not.
did she provide any pictures or
No, she
videos
did
of
not.
any property being damaged?
No, she did not.
Were you, so is it your testimony today that you were not aware of any personal property of Ms. Carson that
No,
was damaged due to the
no,
flooding?
it was never, she had never mentioned it.
Now, when was the next time Ms. Carson informed you about the defect in the
The
property?
next time she informed me was, she said that there was a leak in the roof. And as soon as she notified me there was a leak, and I've owned the property for a while, the first thing I said was probably needs a new roof.
When did she notify you of the, leak?
This was in, this was a year later. I think it was June of 2020. That was the second time she had ever contacted me. I don't live in the property. I have to rely on my tenants to tell me what's wrong with the property. That was the second time she had ever contacted me about anything with that property.
Okay, so this time it was about a leak. Now, did she specifically say it was a leak from the roof, or where did she say
said
the
it
leak was
a leak from
occurring?
the front of the living room. So I presumed that it was the roof because the house had not, the roof had not been replaced. So in my text messages, I told her, can we arrange to have a roofing person come out on Saturday? She agreed to the date, and I had a roofer come out that day and given me an estimate on putting a new roof on the house. I signed the contract that same day.
Did the contractor state that, an entire new roof had to be placed on the property?
Yes, he did.
Okay, and you contracted with that, contractor that same day?
That same day.
Do you remember how much he, how much the contract was for?
$6,500.
When was this contractor able to effectively put the new roof on the
When
property?
we signed the contract, he told me that would be after July, but because of COVID and other issues, it did not happen until August of 2020. I made Kara aware of that by email, by text, and kept her informed. So there's a text record of that.
Now, based off of this leak that was in, you said the front room, correct, in the living room of the home, when Ms. Carson informed you of this defect, did she make mention of any type of property of hers that had been impacted or
No, I
damaged
looked
or
at the
destroyed?
leak when I was there. It was a small leak in the ceiling. And it cost me $140 to get it repaired. And I have a receipt for that as well. There was no flooding in the living room, and there was no furniture. The only thing that was in the living room were 2 chairs and a couch. at that time. And there was no flooding. I have wood floors in that house. There was no flooding on the floor.
And you said this was the second time that you
This
were
was the
notified.
second time that Kara had ever notified me about an issue with the house.
So, when was, and you said that was in June of 2020, right?
June of 2020.
When is the next time you were notified of a defect? Not, I just want the date at this time.
June of 2020, the same day when I was there for the roof, after I met with the contractor, Kara's mother told me that there was a problem with the basement leaking again. And I said, because Kara wasn't there. So I said, well, why didn't somebody call me and tell me? Because I probably would have done that first. And she said, well, Kara was supposed to tell you. I said, Kara did not tell me. So I told her, I said, well, let me try to work out some funding. And then I tried to reach the contractor, that Louis McVeigh, the person who had done the initial work, and I was unable to reach him. I kept trying, I was unable to reach him. So I could not take care of that right away. And then I told the mother, I said, I'm sorry, but I'm gonna have to increase the rent from $600 to $700. That's because the expenses were getting high. So I told, oh, go on.
I just wanted to add, so it was again, June 2020 where she informed you about the roof, and June 2020, you were informed about recurring flooding in the basement. as well.
Yes.
Do you remember around what time, month and year Ms. Carson stopped paying rent on the property?
Yes, Ms. Carson stopped paying rent in July of 2020. And she made her last payment, which was partial payment, and she stopped paying rent July of 2020.
Do you remember how much her partial payment was for?
I know she had a balance left of $425 for July.
Now, when you were, again, informed about the flooding in the basement in June of 2020, did Ms. Carson or her mother or anyone who was in the home inform you of any property that has been damaged or destroyed
No.
because of the flood?
No, they did not.
Nothing.
No, never mentioned it.
So, Ms. Oliver, Ms. Carson has put specific items on the record as to what has been damaged because of the defects that she has reported to you, that she claims she reported to you. I do want to take some time to just make sure that you were not aware of any of these damages, okay? The first one that she has put on the record was a television set. Were you made aware at any time that a television set had been damaged because of flooding in the basement that had been reported to you, or the leak in the front room that had been reported to you?
No,
Have you been informed of any damage to the television based off of any other defects that have been informed of?
never.
Ms. Carson also alleged that a living room furniture set was damaged because of the flood, because of the leak, I'm sorry, that occurred in the front room.
There was never a living room set in that living room.
How do you
For the
know-
time I was allowed entry in that house.
Now, were you informed by Ms. Carson, her mother, or any other
Her
person?
mother told me that she had furniture in storage, but she wasn't bringing it to the house because it was too big for the house, and it was a small house.
So it is your understanding that there was never a living room set in
Never.
the home
Never,
based off of what Ms. Carson?
never.
Ms. Carson also alleges that it was rugs that were damaged because of the flooding. Did she ever bring to your attention any of her rugs that were damaged because of
No,
the
she
flooding?
did not.
Do you remember seeing any rugs in the property?
I
at
never
all?
saw rugs in that house. It was a bed in the living room on the floor. And I was kind of surprised by that because I'm thinking, why do they have a bed here in the living room? Because the house is only supposed to be rented for her and her mother and her daughter, but her brothers live there. So I kept wondering, why is there a mat? And then there was a mattress on the floor.
Last thing Ms. Carson has put on the record that her washer and dryer set were damaged, destroyed because of the flooding in the basement. Were you made aware at any time of a washer and dryer set that had been damaged because of flooding in the subject property?
No, I spent a lot of time in the basement because that was the only, after a while, that was the only place I could go in the house. We'll talk about that later. There was never a washer and dryer in the basement.
just for purposes of clarification, Ms. Oliver, outside of the basement flooding and the leaky roof in the front room, were you made aware of any other defect in the home?
Attorney Jessica, I was just surprised when I heard all of this, because if you'll notice, every time, and I have evidence to prove, every time Kara made me aware of anything in that house, I worked diligently to get it done.
Ms. Oliver, can you please, you can just provide a yes or no answer, outside of the basement flooding or the leaky roof or the leaky front room, were you made aware of any other defect in the
No,
subject property?
I was not. I was never made aware of anything, and all the things she made me aware of at that point were in text messages. And they were polite at that time.
It is your testimony that the only things that you were made aware of in the subject property was the flooding in the basement and the leak in the front room that was caused by the roof.
Under oath, I will tell you that the only thing that I was made aware of about that house was the flooding in the basement twice and the roof. And those things were taken care of.
I would like to direct your attention, Ms. Carson, again, it's been provided in evidence. I would like to bring your attention to Exhibit 6 that has been entered, the property maintenance inspection by the city of Detroit. When were you notified that the city had been called out on the subject property?
In July of 2020, Inspector Katrina contacted me and told me that my tenant had called about emergency repairs to the house. I was surprised because I had one other property and I had never, ever had a problem with fixing any of my properties. So I told Inspector Katrina, and he told me that you have a responsibility as a landlord to bring this into compliance. I made a commitment to him that I would do everything in my power to fix everything that's required in that house. He told me at that time to stay in touch with him and to make him aware of whatever I did related to that house. And I did that. I have email, text messages between him and I myself. Yes.
So I take it that this inspection report came out in 2020 and Exhibit 6 that has already been admitted. What were some of the, what were the things that you needed to fix in the home according to the city inspection?
I must tell you, I was shocked. I was shocked. Mind you, my sister lived there. My sister lived in that house and she remodeled the kitchen. She remodeled the bathroom because again, I'm the go-to person and she won because I was charging her and her husband very little rent. She put resources to remodel that kitchen. She remodeled the kitchen and the bathroom. I had people stay there after they moved. But when I saw the report, I was shocked. I'm like, well, why didn't she tell me?
So what was on the report, Ms. Oliver?
There were several things on the report. There was there was mold and mildew in the basement. That was the first time I was aware of any mold and mildew. Later on, Kara told her attorney that there was mold and mildew upstairs, but that report said there was mold and mildew in the basement. Somebody told me to have my insurance company come out and look at it. The insurance company came out with me. We met them there. And Kara would not let me go upstairs. In other words, my job was to stay in the basement. So I went in the basement. The insurance company went up and saw the upstairs bathroom. We kept trying to figure out where the leak was coming from. I had another contractor with me. My insurance company did not cover the damage because they said that I didn't make them aware of it within 2 weeks. And I said to my insurance company, how can I make you aware of something if the tenant does not tell me? And he said, Ms. Oliver, it is your responsibility to make us aware. The tenant never made me aware that that the basement bathroom, something was leaking. Now, we later found out that the leak was coming from the upstairs bathroom. She kept me away from the upstairs.
What else was involved in this inspection report? So there was mold that was cited in the basement. What
There
else?
was mold. There were broken windows. I called Home Depot about the broken windows. When they came out and did the first inspection, there were 4 broken windows. When they came out to do the second measure, there were 6 broken windows. So the price went up. So the broken windows, The tree needed trimming in the backyard and in the front yard. There was, the basement needed to be redone because there was a, water damage to the basement. There were a lot of things that I was just surprised about.
So let me ask you this, Ms. Oliver, were there broken windows when you rented the property?
No, there
out
were
to-
not. No, there were not.
In 2019, there were no broken windows.
No broken windows.
So you mentioned broken windows, you mentioned tree trimming, the mold, what other things needed to be?
There was,
fixed?
work I had to do. There was plumbing issues. So I called, my go-to plumbing person was Armstrong Plumbing. So Armstrong Plumbing came out one day, and of course, Kara would let me in. So the plumbing, I told the plumbing person to do what he needed to do, and when it was done, to call me. Armstrong Plumbing went to that house several times, and each time they went, one time they went, and the office manager contacted me and said, Ms. Oliver, the tenants there are bad mouth, and this is a conversation between me and my attorney. I have the paperwork to prove it. The tenant is bad mouthing you, and even though, you know.
Let me stop you for a moment. I'll strike this testimony as hearsay. Let's direct the witness.
Thank you. So you, again, you were apprised, when did the city inspection happen?
July of 2020.
Now, from the July of 2020, when you were notified of all these defects.
I immediately started, the first thing I worked on was the lead inspection.
So there was a lead.
There was a
issue as
lead
well?
inspection that I had to do, and then there was an interior inspection I had to do. Plus, there were emergency repairs that the Inspector Ortega told me I had to do.
So let me ask you this, Ms. Oliver, were you able to obtain a certificate of compliance for this property from the city of Detroit?
Yes, I was.
When did you obtain this?
April 27, 2021, and it was the hardest thing to ever do because the tenant would not cooperate. She called on August 31st.
No, one second, we'll get to that. So you mentioned that it took until April 27th, I'm sorry, April 27th, 2021 for you
Yes,
to
it
obtain
did.
the certificate of compliance.
Yes, it did.
What challenges did you face from July of 2020 to April 27th of 2021 when you finally obtained your certificate of compliance?
I was shocked because I'm thinking that the person wants to make these repairs. I mean, you know, but my husband and I were like, you know, we gotta take care of this. You know, we wanted to keep them as tenants, but they were so adversarial. On August the 3rd, we had a contractor, the one that did the lead remediation. He went out there on August the 31st. I was talking to him. He was talking to the tenant, and I was on the other line, but again, I heard this conversation. The tenant was more interested in where I worked. She kept asking, does she work for the Department of Health and Human Services? He said, well, I don't know where she works. Is she paying you under the table? I said, no, she's not paying me under the table. She called the police on him. I had to call Inspector Patenga. I had to call him. He called the tenant and told the tenant that she had to let the contractor in. The police told her, you have to let the contractor in. My contractor gave me the phone. Inspector, the police officer foreign told me, he said, Ms. Oliver, he asked me some questions, my name, my age, all of this, who I was. And then he said, well, your tenant's gonna have to let the contractor in. That was one barrier.
And that was for?
That was for when the contractor was working on the lead mitigation.
What other challenges did you face that again caused you to not get the?
When I did the follow-up lead inspection, I called Watson Environmental Services for the re-inspection. When I called him, he said, Ms. Oliver, he said, that tenant's been calling me. I said, well, what tenant? He said that Kara Carson is over at the property at 14801 Forum. She had called him, questioning him about the contractor.
I'm gonna have to strike the testimony here that unless she heard those statements herself. She was not able to testify.
Okay, here. Okay, let me look at them.
Well, wait for the question.
One second, Your Honor.
Without testifying, Ms. Oliver, to if anyone else has told you or said about getting these repairs done, what obstacles did you face in getting these repairs done after the city inspection in 2020? What obstacles did you personally face with Ms. Carson in order to remedy the defects from the inspection?
It was, and I'm sorry to be emotional, but it was a nightmare. I had to pay contractors to do work for me that I could not see.
That you could not.
I could not confirm that they did it because she would not give me access to the premises.
All right.
And I was trying to keep the peace because she was very adversarial. Every time I did have an opportunity to talk to her, she called me bees. She had other people calling me, cursing me out, talking to me like I was nothing. And I just, it was emotional draining because my husband and I were investing more and more money into the house, fixing it up. And here we had a tenant who were trying to make the place conducive for her to have a comfortable lifestyle. And I was just getting all this negative feedback. So
Ms. Oliver, is it your testimony today that from July 2020 to April 27th, 2021, that the plaintiff, Ms. Carson, hindered you from entering the home to make repairs?
yes, she did, to the point where when we filed a motion for repossession of the property, I specifically asked my attorney to ask her attorney to give us access to the entire house. And her attorney said yes, and her attorney said, you can even take pictures. When we got to the house, we made an appointment. We made an appointment to go see the house, because I hadn't been in the house. Only place she let me go was the basement. So I went and looked at the house, and the attorney told me to take pictures. I took my camera out. Ms. Carson would not allow me to take pictures. So I immediately called my attorney and I said, I'm in the house. She's not allowing me to take pictures. She called Ms. Carson's attorney and was able to get her. Ms. Carson's attorney called her and told her to allow me to take pictures. I took pictures and I was shocked at the condition of that house. I was shocked.
How much would you say you came out of pocket getting in compliance on this subject property to obtain your certificate of compliance?
I have received totally over $40,000 for that property. Over $40,000. And when I looked at it, I had already spent close to 30. And I said to myself, what are they doing to my property?
Is it your testimony today, Ms. Oliver, that the plaintiff, Ms. Carson, contributed to some of the damages in the home?
Yes, absolutely, absolutely. The mold remediate, this is another thing they told it. We sent her attorney, and she said to her attorney that there was mold, and I'm thinking, well, where did this mold come from? It wasn't on the interior inspection report that the city requires. So as soon as my attorney made me aware of it, I called the mold company. As soon as I became aware of it, I called the mold company. The mold company came out and did an assessment. We scheduled them to come out on 4/10. They told us, get a dumpster, do this, do several things. So I sent the information to my attorney, who sent it to her attorney, who was supposed to send it to Kara. They were supposed to clean up the kitchen, take stuff out of the kitchen from under the cabinet, straighten up, move things. They were supposed to not be there for 48 hours, and they were supposed to cooperate. We got there on the 10th. The mold company was ready to go. Kara Carson and her family, her mother and her brother, were still at the premises. The contractor says we cannot enter the house with them on the premises. So I called my attorney. My attorney tried to reach her attorney, could not reach her attorney because it was a weekend. So eventually, after, and the contractor told me, he said, Miss Oliver, we have to leave. I begged him, I said, please stay. Please stay. And he said, I'll wait for about 40 more minutes. So finally, Kara and her mother left. Then her brother was there, who's not even on the lease. Her brother was still there. He's not even on the lease. So the contractor said, I'm not going in as long as he's here. So my husband went over to him and convinced him to leave. He left. We went into the house with the contractors and they said, Ms. Oliver, we can't touch any of it. The kitchen was a mess. A mess. I have pictures. The kitchen was a mess. My husband and I had to clean the kitchen and get their dishes and stuff out so the contractors can do their work. We left. About 2 hours later, the contractor's manager called me. The manager called me and said, Mrs. Oliver, he says, my crew called me. Apparently one of the tenants a male came back with some friends and they were parked in the front of the house. And as the contractors were bringing stuff out into the dumpster, they were harassing them. He says, I felt it was unsafe for my technicians. So they had to leave. They had to leave.
One moment, Karen. And again, for purposes for your, Ms. Carson had stopped paying the rent in which month?
July of 2020. When, after he told me they had to leave, he told me they were able to get some things done. He sent me a letter, and I have it. It said that they will not return to that property ever as long as those tenants are there. I have that in writing.
And Ms. Carson moved out of the property in which date?
August, well, let's talk about that. Because she was supposed to move out she signed the repossession of property that she was going to move out on June 4th. On June 5th, my husband went by there and she told him we had the date wrong. So my husband said, well, what date? And she said, well, my attorney gave me another date. And my husband said, well, let me see. She would not let him see anything. I called my attorney. My attorney called her attorney, couldn't reach her. But finally, there was an email message from her attorney saying Kara knew that she was supposed to move out of that house on June 4th.
So what date did she end up moving?
She did not move until August 8th or 9th. We had to get another repossession of property from the court.
Now, that paper in which you were speaking of, giving the date for the initial move out, was that a consent judgment?
It was from 36th District Court. It's a repossession of property.
Okay. So it is your testimony again, Ms. Oliver, that Ms. Carson did not pay any rent from July 2020 to August 8th or 9th, well, to August 2021, correct?
You are absolutely correct. We did not even want anything from them at that point. We just, at that point, with all the frustrations and all of the problems, there was another time we had another plumber go out there, Armstrong Plumbing, who had been, and I wanted to keep people that were familiar with them because they could deal with them. So Armstrong Plumbing told me, well, I can't do hearsay, but they went out, they had to fix piping again, and we just realized that they would keep breaking the same things. We kept paying.
I have no further questions at this time.
All right, thank you, Council. All right, Ms. Carson, you have the right to ask questions of Ms. Oliver relative to her testimony, relative to things that occurred in this rental relationship. And again, you have to ask questions. You can't argue with the witness. You can't make statements. You can ask her questions, and she has to answer questions that you may have. So you may come to the podium now, ma'am, and ask the questions that you may wish to ask. This is cross-examination, so you can be very direct with your questions. Your questions can be open-ended because it's cross-examination. All right, so go right ahead.
All right. Okay, Ms. Oliver, so I moved in 219 and you said that I text you about the property.
Yes. There's a copy of the text messages on the table.
Okay, the next question is, you said that I like contacted you twice about the condition of the house? That was it?
I believe the testimony was that within the approximately the first year of the relationship, the testimony of Ms. Oliver is that she received two communications, one regarding the basement, and then subsequent to that time, one regarding the roof.
Yes, and then,
Well, your question is,
my question is, July, once the city inspector came out in July of 2020, why did it take so long for you to finish up the work the whole next year in a property that you said you were shocked about, that you had like several years?
Because it was very difficult to get contracts. If you recall, when I brought a contractor to the house to look at the basement, you asked him his name, his car number. This was my cousin from Lansing, who's a well-known contractor in Lansing. And he refused to come back and work. It was very hard getting contractors to work with you and your family.
Your Honor, I wanted to know why too, that I had to refer contractors speaking with your management company several times.
You referred Louis McVeigh to me, who ended up not doing the job. I was no longer to find him. He also referred Brian Harrison to me because he said he was a licensed electrician. You referred him to my husband. He did. My husband paid him several, almost $1,000.
I don't have nothing to do with that. I have another question, Your Honor.
well, yeah, I believe that you testified that previously, ma'am, that Mr. McVeigh was paid something in the nature of $1,100.
$1,100. That was
Let me
the
stop you. And this was someone that was referred to you by
Kara Carson.
by Ms. Carson. All right, Ms. Carson, you may continue with any questions that you have.
Okay, and Your Honor, when the mold came, you say you didn't know about the mold. You had to know about the mold because it was an inspection report. But why did it take you to April the 1st, 2021 to even target the mold? Period.
The mold on the inspection report specifically says mold in the downstairs bathroom in the basement. Yes, it does. And that's the mold that we were aware of. I never went into that upstairs bathroom until I got permission to. And then that's when you told your attorney about mold in the upstairs bathroom. That was not on the inspection report, mold in the upstairs bathroom.
Well, you can answer the question about that, ma'am.
Yeah, I wanted to know, why did you say that you were shocked about the mold in the house and in the whole basement and you knew that?
I was shocked about the mold in the basement because I didn't know that there was a leak from the upstairs bathroom downstairs. Oh, because if someone had told me about that, Kara, if you had told me about that, that would have been fixed.
You're a property management company, but this is another thing. You had told the court that we kept breaking stuff in the house, pipes and things.
I'm sorry.
How can I break a pipe? You just told the court that we broke pipes and stuff. We had to come.
When we had a plumber to fix the upstairs kitchen because we were doing hair in our house.
I wasn't.
So we had a plumber fix an upstairs. She was.
Well, that's not really the question.
Okay.
The question.
We had a plumber fix that upstairs pipe several times. He told me that he had fixed that pipe. We couldn't get in. So whenever you told me something needed to be done, I sent a contractor over there. So I was spending money to not be able to review work that I was paying to get done.
This is one more thing, Your Honor. So you were saying people do work on the house. I was trying to figure out when your husband was doing work on the house and blew out the electrician, what was the purpose of him coming over? If you was saying he was hiring people, why you didn't hire nobody electric? Because he could have died trying to do some electric people he could do.
You mean the electrician that you referred,
No.
Brian? Do you remember Brian Harrison that you referred?
I know that's all the people I referred. I shouldn't refer to nobody.
Okay, what's your question now? Your question is, why did she use her husband as opposed to some other person?
Electrician company, when he did the electric and it popped out, he like, oh, I gotta wait till tomorrow, it's pretty cold outside.
All right,
And
let me stop. All right, you understand the question, ma'am?
I don't understand because I wasn't there.
So the question is not whether or not you were there, whether you understand the question. The
No, I
question
didn't
is-
understand.
All right, let's make sure you understand the question. The question is, why did your husband do the electrical repairs rather than hire someone? That's the
My
question.
husband did not do electrical repairs.
Your Honor, can I say one thing?
Well, no, you can't really testify here. You,
No, but, in the midst of it, why did you forge my name? I'm sorry?
the question is, did you forge your
Forge my
name?
name on the lease?
Yeah, why would I forge your name on the lease? Why would I do that? I mean, what motivation would I have?
Let me ask you let me stop you for a moment, ma'am. The question is, why did you forge your name on the lease? Now, your answer is,
I didn't forge your name on the lease.
all right, thank you, ma'am. Your inquiry.
Okay. I was wondering, once the lease and me, you got into the argument that day, you stopped coming over and you sent your husband. Why was that?
Because it was very stressful for me, dealing with people that were very hard to deal with. I had to take myself, you wouldn't let me into the premises, you only allow me in the basement. So it was very stressful dealing because every time I come over, you curse me out. You have friends and family that cursed me out. Before the inspection, this re-inspection that was trying to get certified, I came over there on the 25th of April and cleaned the picture that you have that we kept for the record.
I believe that you're beyond, that's all right, Madam Officer. Ma'am, I believe, let me
Cleaning your
stop you.
house.
Let me stop you, ma'am. You're beyond the scope of the
I'm sorry.
question, ma'am. All right, your next question, if you have one.
Yes, Your Honor. And, one more thing that I have to ask that was very important. So it was a flood 2022. So she said she do everything she said. She never came went over to unflood her property, but she did everything.
Let me stop you, ma'am. Let me stop you. The testimony in this case is that when the defendant was informed of water conditions, a flooding condition, she said that occurred a few months after you moved into the property. That was when she was first informed. So I guess your question is, why didn't she come over when you informed her? What is your question?
No, my question is, she said that she have a history with the plumbing company, such as the plumbing company. Why didn't she get the plumbing for whatever with the water situation fixed? And I know she would have got it fixed. She knew about the plumbing, the mold, because of the mold. That's what water makes mold. That's what I'm saying. Why wasn't she didn't come over and fix the whole plumbing situation instead of keep having a snake?
Well, before we pose that question to her, it seems that the testimony here is that at some point you informed the defendant regarding the plumbing condition, the water condition in the basement, and that she and yourself agreed to a Mr. McVeigh taking care of the problem. Is that so? What is your question in that regard? Are you saying that did not occur? Let me stop you. Are you saying that did not occur? Because you can ask him.
No, it occurred, but I said once he did the work, he said if she had anything else, it'd be on the outside. My thing about it was why she didn't get the plumbing fixed complete.
All right. So after Mr. McVeigh's work, why didn't she complete any other plumbing work that may have become necessary? Is that what you're saying?
Well,
or I guess
the whole plumbing situation.
You're saying that at the time that Mr. McVeigh made the repairs, that it was a bigger job than what he did, correct?
Basically, yes, because it's still.
Let me stop you. It ain't no trick question. I don't know what the question is. I'm trying to formulate it for you. So
yeah, I'm just wondering.
Stop. No, I'm trying to formulate it so we can get to the answer. Are you saying that there was more that needed to be done at the time that Mr. McVeigh came? All right. So your question is that at the time, did she in fact know that there was more stuff that needed to be done?
Yes.
All right. Do you understand that question?
Yes, I do.
All right.
Mr.
Let me
McVeigh,
stop you. Did you understand at the time that Mr. McVeigh performed some work, that there was other work that was needed?
no,
Okay.
Mr.
All right. Let me stop you. Your question is, your next question there. She says her testimony is that she did not know that there was other work that needed to be done. You can ask other questions
You did
about
not
that.
know that there was other work to be done because he informed you once he left, there was other work to be done. It's on the outside.
no, he did not. You weren't even there when he
Let
was
me-
there.
But you just
Now,
said,
let me stop you.
No, he
Let
did
me
not.
stop you. It doesn't matter whether or not she was there.
He did not inform me.
Listen, ma'am. Listen, you got to listen to the
I
question.
am trying to listen.
Yeah, no, you're not trying hard enough to listen. You're trying to talk. And I don't mean to say that to speak down to you or anything, but I believe that you can answer the questions if you will just listen to the question. That's what I need you to do. All right. So, ma'am, your inquiry is whether or not Mr. McVeigh informed Ms. Oliver, that there was additional work that was needed regarding this basement
Yes,
situation?
he
No,
No,
he did not.
that's the question that
did.
you're
Yeah,
asking.
yeah,
her.
that's what I'm.
Let me, all right, ma'am. Did he inform you that there was
No, he
additional?
did
work?
not.
All right. Now, I understand that you have something that you want to say, but this is not the place for you to say anything. This is the place where you ask her questions, okay? All right, go ahead if you have other questions, ma'am.
I just have one last question. My question is, I just don't understand, by being a management property, should nobody have to inform you on anything about your property? My thing about it is, why you didn't come and fix it on your own?
Okay, let me stop you before you answer that question. The question is somewhat twofold. The first question is, as a property management company, are you supposed to remain aware of the conditions of the property?
I think I have learned that lesson. This has been a very valuable lesson to me, Mrs. Inspector, particularly because I have another property, I'm used to a tenant notifying me and it's in the lease. So yes, I am very well aware now that I need to do an inspection myself because I've learned that lesson.
All right, the second part of that question is it in fact true that one of the ways that you find out if something is going on the property is if the persons who are living there inform you of that?
That is the best way because I want my tenants to be comfortable. And I want my tenants to be comfortable.
All right, I know that you said that it was your last question, but if you have something else to ask under these
Yes, I
circumstances,
have one last.
go right ahead, ma'am.
She said that she want her tenants to be comfortable. You knew it had mold and stuff in there, and you knew it was problems, and you wanted someone to be comfortable, it shouldn't have took you that long. And that's the problem with the question I have.
All right, so it sounds like to me that the question that you're asking is it in fact untrue that you wanted your tenants to be comfortable and that is untrue because you didn't move as quickly as you could have? That's your question.
I moved very quickly. When I became aware of the mold in the basement, I mitigated that. When I became aware of the mold, after you told the attorney about the mold upstairs I had never seen, I called a rapid mold. My records will reflect every time something came to my attention, I acted on it.
Mold should be targeted first. Why didn't
You never
target
told me
mold
about the
first?
mold.
Let me stop you for a moment. Sounds like your question is, should the mold have been
Yes.
targeted first? That's the question.
It was the mold in the basement was targeted. I had the
The mold
basement
in-
bathroom completely remodeled. I didn't learn about the mold upstairs until months later when you notify your attorney. It was not on the inspection
Thank you,
report.
ma'am. Thank you, ma'am. Ma'am?
I was wondering, April 1st, 2020, you had them to come over to get out the house for the mold. Why did it take that long?
Because I had just been made aware of it through my attorney, from your attorney, that there was mold upstairs in the bathroom. Because when I got the email from my attorney, I said, what mold? The mold in the basement's been mitigated.
That's all you have.
All right, thank you. Thank you, Council. Thank you, Madam. Council, any,
I do have one
redirect?
follow-up question, Your Honor.
Yeah,
just
you
one.
may at this time.
There was testimony in regards to Mr. McVeigh's services that he provided.
Yeah.
Did Mr. McVeigh, after he performed the services that you contracted with him, for the $1,100, after the service that he performed, that you paid him $1,100 for, did he make you aware of any other issues within the subject property regarding the fund?
No, he did not.
That's all, Your Honor.
All right, thank you. All right, ma'am, let me ask you just a couple questions, and if it generates additional questions by the parties, I'll allow them to ask. At the time that you entered into this relationship with Ms. Carson, there was a couple of things. One, did you do a inventory checklist on the property?
No, I did not.
All right, and you indicated that when she moved into the property, that she agreed to remove some items that were existing in the property, and she agreed to paint the property. Is that correct?
Yes,
Now, was that information or what was that agreement put into the lease agreement at all?
No, we talked about it, and in our text messages, I asked her if she paid, so that was in the text message.
All right, thank you. Any inquiry based upon the court's question,
This, to be more specific, sorry, just to be more specific, I believe you did testify that there was number one, you testified that she kind of moved in on an emergency basis, right?
Sorry.
You
Yeah.
testified that she kind of moved in on an emergency basis?
Yes,
Okay, and there were some clothing items in the home at the time that she first came to look at it, correct?
yes,
But you moved those items yourself.
yes.
any question that you have based upon the questions that I asked?
No, you're not.
All right, thank you. All right, you may step down at this time, Ms. Oliver. Thank you, ma'am. All right, Counsel, anything further at this time?
Nothing further, Your Honor.
The defense rests at this time.
Yes.
All right, ma'am, this is an opportunity that you have to come up to the podium if you wish and to say something in rebuttal to things that you've heard. It's not a closing statement yet, but this is your opportunity to give a rebuttal to say that the testimony said this, but this is what happened here, or this is what happened here. That's like rebuttal testimony, right? You may come now and tell me anything that you wish to tell me.
Talking
regarding
about
the-
the process of the house.
Sorry.
Throughout the process of the house that was.
Well, this is like additional testimony. Now that you've heard the case, is there something else that you wish to tell me about the case at this time?
Yes, at the end of the day, Your Honor, everyone is human. She didn't get things done that what she wanted. She wanted to paint a picture of me. I'm 42 years old, Your Honor. And you know, at this level, young people overreact. She's saying that I did all this and around me, but it was the opposite of way around. Everybody that came over, she had them thinking that we were the bad person, had guns, everything coming over. I stopped dealing with her after me and her got into an argument over the lease. She said, Kara, can I tell you something? It was me and her husband standing down there. She said, can I tell you something? I'm gonna send you a copy of the lease. After then, I stopped dealing with her and I started dealing with the husband. So at the end of the day, she didn't really seem like she took us through more than what she took us through. Then after then, you know, we went through a lot, however, I understand that, you know, it's responsibilities on both ends and it's a time limit and all like that, but one thing I do like to say about the case, honesty is the best thing you can do with the case. So at the end of the day, it's like going through it and just on the opposite shoe, them two different shoes. So at the end of the day, yes, it was a lot going through the case. We went through a lot. It was just like, to me, on our end, nightmare through M3. And I'm just happy that it got to the end and we did have to leave or whatever like that. But at the end of the day, once that we left, she said that she put in another repossession of the house, but the city of Detroit came out and got us stuff out the house. So I'm trying to figure out how did she do that when the city of Detroit came out to the house to rescue us out of it. So we had to be out of there immediately because they didn't want us to die. So on that note, it's just a long case that I never been through this ever in my life. So I really don't know what to say, what to do or whatever, but I just put whatever I went through the madness of this case. It is like unbelievable, not understanding. It's a lot of things to go through. And I'm just happy that I am here today to still test my testimony of what went on. And at the end of the day, I just feel like I myself would never own a house if I have to go and take people through our home. Because if I can't afford it, if I can't afford to keep it, it's no need for me to have it. So at the end of the day, I learned a whole lot of lessons and a whole lot of stuff. Like at this day, Your Honor, I'm still homeless, but I I know if I ever, in the midst of it, I have been helping tons of people that's going through stuff, homelessness and everything that they're going over. There's people out here going through a whole lot of stuff, and I'm just thankful that I am at the end of what I'm going through. And just hopefully that I do end up with a place to stay so that I can call home and I don't have to go through this again.
All right, thank you, ma'am. And as you take your seat, any inquiry by way of cross-examination of this witness?
No, Your Honor.
No, no.
All right, the parties have rested in this matter, and all of the evidence is in this case. And are you prepared to argue to the court as to what you wish the court to do? All testimony is already taken. This, you get to go first again with being a person to summarize what you believe your case has shown and what you're asking the court for. What you're asking the court for, what basis you're asking, whatever you're asking. Present that to me, and the other side will give their closing statement as well. And then you get the last word because you have to proof in this case. So now you can start with your closing statement.
Okay, Your Honor, I was here asking the court for 17,000. No, I did not have medical records. My mom just got buried like at least not even 2 months ago, so I haven't went through stuff to get it. It's laying right there. It's just a shock that she's gone. So I could have just went through it and picked it up and whatever like that. I did. So at the end of the day, I was just asking for right thing as to what should go right for as this case on my end, because I don't have no attorney, I don't have any help at this time, but at the end of the day, I know right is right and wrong is wrong, and I know that I just wanted for it to be over with, because I have been through a lot on that end, and I just want to be over with. I want the court to say why would they think that should be best on my behalf.
Thank you very much, ma'am. You may be seated at this time. All right, for summation, counsel, you may at this time.
Thank you, Your Honor. I think the court summed it up best earlier when it was given its brief synopsis during the direct resolution that this is a perfect storm of some condition.
And you would keep your voice up a bit, Mr.
Yeah, thank you, Judge.
My court for it. I was sensing that she was struggling just.
Right.
I'll talk louder. I'm sorry. Just from my client's perspective, I mean, the court was there to witness how emotional she got on the stand. This is a bit of a good deed that just on no good deed goes unpunished. You know, it's saying, Your Honor. Plaintiff in this case moved into the subject property on a bit of a emergency basis. As the defendant testified on behalf of her company, she was the go-to person. If someone needed a place to stay, call Evelyn. She'll try to help you out as much as she can. There's testimony on the record that plaintiff was staying in the hotel at the time. She came into contact with Ms. Evelyn and contacted her about staying at the property. They entered into a lease agreement. The lease was for a reduced under market rate of $600 a month. She only asked her for half a month's worth of security deposit. So she got to lease the property for $900 at $600 a month. The lease that was entered into evidence as Exhibit 1 or Exhibit A indicates, and it was signed off by the plaintiff, that the property was in fact in good condition. That's not necessarily in perfect condition, Your Honor, but the property was in good livable condition. There's testimony on the record, Your Honor, that throughout the terms of the lease, before this inspection report, there were only 2 times that the plaintiff actually indicated to defense that there was an issue with property. First, there was an issue with flooding. What did my client do? She got in contact with somebody and she addressed it. She paid $1,100 for the basement to be dug up to address the issue with flooding. person who did it never indicated that there was additional work that needed to be done. The second issue, a leaky roof. What does my client do? She addresses the issue. My client testified that she paid $6,500 for the roof to be put on the property. She testified that she herself witnessed this leaking that was inside the property. She said it was contained to a small area. Plaintiff indicated that she had property damage. She lost a TV. There was no TV, no picture of a TV. Estimate for a TV entered the evidence. She indicated that she lost property, furniture. There was no pictures of damaged furniture, no furniture entered into the evidence. Your Honor, as my client testified, she witnessed herself the living area where the small leak was. There was no TV or furniture in that area. She indicated that there was flooding in the basement and that she had a washer and dryer damaged because of this flooding in the basement. My client testified that she was in the basement multiple times and she never witnessed a washer and dryer in the basement. Your Honor, my client testified that throughout the course of this whole ordeal, she's out of pocket nearly $40,000. She dug up the basement, she got a new roof, and she did whatever she possibly could in order to remedy the issue. The plaintiff told her about the issue, she remedied the issue. In July 2020, this is 13 months before the plaintiff actually moved out the property, my client did not collect any rent. That's about $7,800 based on my calculations of $60 a month, 13 months without rent. She understands that there was an inspection done on the property and there were things that were needed to be completed. And she did what she could. She hired contractors, she got inspections, re-inspections, came out the pocket to make sure everything was done properly. And of course, as everyone was aware, this is a period where you deal with COVID and it's hard to get contractors. As she also testified, the plaintiff herself contributed to the delay. She would prevent contractors from coming to the property. There were conditions that she said she was not responsible for. She testified that there were broken windows at the property, but when she conveyed the property to the plaintiff, there were no broken windows. She indicated that there were broken pipes at the property. When she conveyed the property to the plaintiff, there were no broken pipes. Your Honor, I submit to the court that, yes, issues came up with the property, but per the lease agreement, the plaintiff was supposed to indicate to the defendant what the issue was, and she did on 2 occasions. And on those 2 occasions, my client acted as swiftly as she could. And those were during the periods when she was collecting rent. However, Your Honor, in July 2020, 13 months before she actually exited the property, she stopped paying rent altogether. Your Honor, I understand this is an unfortunate situation, but it started out with my client and in fact trying to help the plaintiff. There has been no proof of any type of monetary damages on behalf of the plaintiff. She indicated that she couldn't take some stuff out of storage, but I mean, it's undisputed, Your Honor, that the stuff was in storage before she moved to the property. That's not the responsibility of my client. Your Honor, it was testimony that the damages were confined to the basement or that small leak in the living room because of the leaking roof that was repaired. And my client paid $6,500 to get repaired, Your Honor. But I do not believe there was any evidence presented to show that the entire property was uninhabitable or that the property was unlivable. And Your Honor, when the special report finally came down that said X, Y, and Z need to be fixed, some of which my client had no idea about because that was not the condition of the property, when she conveyed it to the plaintiff, what did she do? She did everything she was supposed to do. She hired contractors, she got re-inspections, and as she stated, she's out of pocket almost $40,000 for everything she needed to be done, Your Honor. Your Honor, it is the defense position that based on the preponderance of evidence, plaintiff has not established any damages in this case. She has not established her claim that the property was uninhabitable or that she was constructively evicted, and we're going to ask that her case is dismissed.
Thank you, counsel. All right, ma'am, and you get the last word at this time, Ms. Carson, regarding what you believe this case shows.
Oh, yeah. Okay.
I can't hear you.
No, I said, I remember what I was gonna say, I had to get.
All right, take your time now. Take your time.
When he said, well, I think about it is that they were saying that she did stuff as quickly as she can. When the report came out, he had several things that violated, things that a tenant cannot even tear up, break or nothing. So if you said that the only item that you get use of the basement, mold was throughout the whole basement and you didn't see it, I'm trying to figure the whole thing out. Because by you just walking in the house, you smell mold smell. So by you going in the basement, and that's the only access she said she got at all times. How did she even see a mattress upstairs or anything that she's talking about that right on the floor? And another thing is, he said that you don't have no pictures or no damages of washing machine, dryers, and nothing like that. In the instance that you're going through something and you have stuff going on, you're not going to just say the washing machine and the dryer and put it to the side, let me take a picture, because you have stuff going on in that instance, and different people react to different things. But at the end of the day, by you being a property management company, there is no way you should say you work it as swiftly as you can, and you testified that you had this property for several years. Why do it have that many damages going on? And you say your family lived in there. I know quite sure other people have told you about damages before then. But for you to have an inspection report with that many plumbing, electrical, roofing and all like that, that's been an issue. It's just not come about. She knew about it, as you can see, because the inspector, the one was telling me about it, because I said, where did the mold come from? They was like, well, you can't put mold in here, but it was an extreme amount. That's why I asked her. So at the end of the day, the mold situation by itself is like, that's a problem, but we never had heat for a whole year. By flooding, your electric tank and all that. She said she never came to the premises, but she hasn't came to the premises like that, because when she came on the day that the inspector came, she walked up to my door and she said, hi, ma'am, and you are, and I said, Kara. And she looked and she said, oh, I haven't seen you before. Do you have an idea, whatever? Because I want to know who's living in my property. That's what she said. You should know who I am if you came over here. So at the end of the day, it's just was too many problems that was going on for her to say that the tenant should have to be aware of it when you already knew about it. So that's all I have to say. That's it.
All right.
I'm sorry.
Just one moment, everyone.
How's everybody?
I think you're in the wrong spot, right?
I think I might be as well, Your Honor. I thought I was going into Judge Ford's room.
And I think the other gentleman is in the wrong place. What did you say
He's
now?
with me. Yeah, that's my client. We thought we were assigned to, and the last we heard, she was in here.
335 now.
335. Okay, thanks. All right. John, it's gonna be 3360335.
Correct.
Okay.
That's where I was at. Okay, I'll go back.
All right.
Thanks.
Mhm.
All right. The court has listened to the testimony offered in this case, and all of the testimony and evidence is been offered in this matter. The court has also listened to the summations, the closing statements and arguments of the parties regarding this matter. This is a matter that sounds in landlord-tenant law, given the fact that the parties entered into an agreement to lease a certain property located in the city of Detroit at 14801 Quorum. The testimony in this matter establishes that that lease of the property occurred sometime in the month of April of 2019, and that ultimately the parties, the relationship was ended after the matter was taken to court, and the parties either came to some agreement and or there was an issuance of a court order for the tenant to remove herself from the property. The tenant has testified that certain city persons came in and told them that they had to leave the property, and that would have been in August of 2021. I would note that the testimony in this case seems to indicate that a certificate of occupancy regarding the property was secured sometime in the month of July of 2021. And so whatever conditions there were upon the premises that was preventing there from being an occupant, a certificate of occupancy had already been resolved by the time that the tenant had to move out of the property. That seems to be the testimony in this case. Now, backing up, then, what this case is about, the real heartbeat of this case is where the parties start. And this, the testimony in this case seemed to point out that the tenant reached out, that is, Ms. Carson, plaintiff in this matter, reached out to Oliver Management in an effort to rent the property, and that this relationship may have arisen by someone who was a relative of Ms. Carson, who had informed her that there was a person seeking to rent the property. The testimony seems to suggest in this case that at the time that Ms. Carson was seeking to rent the property, that she was in a significant issue of dire straits, where she may have been residing in a jail or something along those lines. I think that's the testimony in this case that establishes that as a result of that, she was desperate to move. She needed a place to move, and that she and her mother and ultimately her brother would be persons that would be occupying the property. Ms. Carson's testimony is that she provided an opportunity for Ms. Carson to come to the property, and after observing the property, that she decided to rent the property. Ms. Oliver says that part of the agreement was that Ms. Carson would be responsible for moving certain items out of the property and for painting the premises. Here is where this case really falls apart. The relationship falls apart before it ever gets started, and it falls apart before it gets started, not because there is perhaps maybe some benevolence at reaching out to someone that is in need of a place to live, and reducing the rent to the low market rate. That's a part of all of this, but the bigger part of all of this is that neither party really set themselves up to really engage in this relationship, because there was not a certificate of occupancy before the relationship began. There was more significant, even that issue was that there was not a proper inventory checklist, some walkthrough of the premises with some written document describing what the nature of the premises was at the time of entering into the agreement. And that's usually something that is broken at the beginning, doesn't get repaired later on. There's some things that you can only really get off on the right footing if you get off on the right footing. And getting off on the right footing is having in both parties possession and something that you can present to the court together with the lease, a document saying with specificity exactly what the condition of the premises are. That inventory checklist describes each room, describes what is working, what is not working, describes conditions that exist on the premises, describes what conditions might be in disrepair, what conditions might be in the process of being repaired, et cetera, et cetera, et cetera. Under the law, particularly in the context of a residential setting, there is a duty that is inures to persons renting property to provide evidence that that property is in a suitable condition where the property is being rented for residential purposes. I think that most folks know that if you're renting a leasehold that does not involve residential property, you could lease 4 walls with a building full of trash because it is not for residential purposes. And if the parties agree that, we want to rent these 4 walls with cracks in them and full of trash and no toilets or anything else, you can do that because it is commercial, not residential. When it's residential, that's where the issues begin to come up, because in a residential setting, you got to make sure and you got to provide some evidence that you're renting a property that's in a reasonable state of repair, such that any conditions that might exist on the premises do not unreasonably interfere with habitability. Doesn't mean that a property has to become quote unquote uninhabitable, nor does it mean that a property has to be perfect. The prospects are that no property, unless it's newly built, and sometimes even newly built, is going to be quote unquote perfect. I think that sometimes when problems start occurring on the premises, what parties start looking at is how imperfect the property is. And it doesn't mean that it was ever perfect. But of course, if my toilet is not working right, then this whole joint is messed up. And I exaggerate a little bit, and I'm not saying that is the facts of this case, but certainly if I'm renting or leasing somewhere and the toilet doesn't work, then the whole place is crap. If the basement is flooding, water is coming up, the whole place is crap. That may not be true, but the perception will be that this place is a dump because something has gone wrong. Well, we know that in this property that there are some things that either were wrong or went wrong and that persisted for a time. And we know that there were significant issues. And why do we know that? We know that from the testimony. We know that from the testimony of Ms. Oliver that says that in this window she spent some $30,000-$40,000 to bring this property up. When this was a lease agreement that lasted for less than 2 years, there was some $40,000 worth of stuff that had to be done secondary to inspections and reports that were made regarding the condition of the premises. That by itself is significantly telling. We also know that the tenant was able to continuously reside in the premises in a significant way, notwithstanding the fact that there were a number of repairs that had to be done on the property. All of this really does relate back to signing an inventory checklist, going through the property and showing, putting on in some type of document what is or what is not going on the property. Because when that does not occur, then this is left to the perspective of the various parties as to what they perceive is going on in the property. The fact of the matter is 2 things that I know for sure. I know a lot for sure, but two things that's easy to give some assurance about. Number one is that the tenant did not want to occupy a property that was in less than a suitable state of repair. Number two, the Olivers did not want to rent a property that was in less than a suitable repair. How do I know that? When water is coming into a property, I don't care how much ownership you have and so on and so forth. If you don't stop the water problem, you might as well have your house demolished because the water is going to take care of most of that. The second thing that I know is that relatively quickly when Miss Oliver was informed that there was a roof leak, there was not a team to come out and do a patch job on the roof. No, there was a company that came out and removed the roof and reshingled, did a reshingling of the entire roof. This is a commitment clearly to try to maintain the property, something that's suitable for renting and suitable for persons to occupy. The problems here relate to not documenting what was going on with this property from the beginning. That's the problem. And that's a problem on both sides, but the burden of that problem rests more in the hands of the persons, the parties occupying, or strike the parties offering the property for residential lease. The parties doing that, they have a presumptive burden to establish at the very beginning that the property is in a suitable condition, and that it is not likely, that condition is not likely to deteriorate over a short period of time. In other words, we've not just come in and put a patchwork here, and just to get by, but that the property is stable and that it is likely to remain stable. Now, we all know that even in your best guess, that something can go wrong. You know, a pipe can burst, tree limbs can get into the sewer line, and so on and so forth. All these things can occur. That's a part of it. That's the chances that people take. But at the very outset, the parties have to put themselves, and primarily the landowner has to put themselves in a position where they're able to show demonstratively that this is a suitable place to rent. You do that in two major ways. One, with a certificate of occupancy, and with a current and valid certificate of occupancy. And the second thing is with a walkthrough that drills down in a document showing where the parties can sign off on what goes on in the living room, the bathroom, the basement, so on and so forth. Of course, a part of all of that is a lead inspection, so on and so forth. Well, this case came of age by doing the last things first and the first things last. And that's what the flip side of this case is all about. You're doing the first things last and the last things first. This property should have never really been rented out. It should have never really been rented out without the certificate of occupancy and without, at a minimum, there being some type of walkthrough inspection to see what the conditions of the premises were. My finding in this case is that certainly there were conditions on the premises that unreasonably interfered with reasonable habitability. There were valiant efforts to try and remediate those conditions, and indeed those conditions were in fact remediated over time, and they were remediated without there being a significant reaction to the dollar amount. It is significant to spend $40,000 over a 1 year period. To spend that amount over a significant period is a lot, but over a 12, 13 month period of time, that's a lot to spend over that period of time. So yeah, there was an effort to remediate. And did the parties fall out? Of course they fell out. Was there some unpleasant exchanges that occurred between the parties? Of course. One may say that I was brutally cussed out by a sailor. And another person says, well, I was acting out of my frustration. I didn't say that much. I don't really care about all of that. The fact of the matter is that anybody suggests that this was a nice walk in the park and that the parties were nice to each other as this heated up, that much within the realm of common human sense, we know that did not occur. But that's not really ultimately the issue here. The extent to which the parties may have had some personal dislikes or displeasures with each other, you have to work that out within the context of your own desire to be the best human being that you can be. This comes down to what happened to the property. What did this mean for the plaintiff? What did this mean for the defendants? And what is the ultimate outcome? How high does this boat float, or does this boat sink? So on and so forth. All of those kinds of analogies that we can use. In this situation, what becomes critical here is the fact that there were 13 months where no rent was paid on this property, and that the property was continuously occupied, although there was some demolition in the value, the reasonable value of the rental of that property. The property was set at $600 a month. There was a notification that the rent should increase to $700 a month. And if I calculated the rental increase at $700 a month, then it would be $9,100. But it's going to be hard to have a calculation that rent should be increased to $700 when the conditions on the property are requiring an investment of $40,000 to get it up to a place where you could get a certificate of occupancy. So a certificate of occupancy. So we stick to the $600 a month. Then the 13 months of no payments were in the nature of $7,800. That's the calculation. That's how much rent was withheld over that period of time. And maybe that was the right thing to do. Maybe the conditions were such that rent should not have been paid. The tenant testified about there being some deterioration of conditions on the premises. She testified that she spent some money to remedy some situations. But if you take this situation and oh, by the way, I'll say this to all parties. One of the most interesting things that I encounter in my work, which Mr. Potts in October, it'll be 30 years as a judge. I don't even know how to say that with a straight face. It'll be 30 years. My daughter was like 6 when I became a judge, and she's now a judge. So that shows you how crazy that what happens with time. But actually, it'll be 30 years in October. And one of the things that happens all the time is people have a way of shaking their heads and stuff. And that's one of the critical lessons that I learned about being a judge, is how the shaking of the heads and all that kind of stuff, it has to go right over your head, because it doesn't matter. It really doesn't matter. During the case and sometimes after the case, people are shaking their heads and nodding in this direction and so on and so forth. None of that matters. The bottom line is that I get a chance to hear it. I get a chance to hear what was put into this case. I get the opportunity to decide exactly what this case is about. Now, if a person is occupying property, there's interferences on that property, it reduces the value of that property to them. This $7,800 was withheld. If we talk about reduction of the value, reasonable value, valuable use of the property, then even if I reduce the valuable use of the property to and say it was $300 a month. In other words, at $600 a month, withholding that amount of money is significant, because even if I knock off half and say, well, she shouldn't have had to pay $600, it still would come to almost $4,000 if I cut the rent in half. If I cut it by a third, it comes to over $5,000. I think everybody knows how this is going. So that I can't say that money that was withheld is not significant money that's involved here. And thinking about the amount that was withheld is a significant part of how the court governs what the outcome of this case must be. If the tenant had continuously paid rent throughout the experience, while the landowner was spending $40,000 to bring the property up to par, then maybe the tenant's claim for damages would be of a much more significant level than what might even be suggested by this case. But the withholding of almost $7,800 is really a significant huge issue in this case. And on top of that, to think about the fact that there was some exchanges going on between the parties, and that even though there is major disagreement, that there were efforts to really get this property right. And that is not only on the part of the Olivers in this matter. Miss Carson brought to the fold a gentleman to correct the problem in the basement. Unfortunately, it did not work out totally, but even in the beginning, she was trying to get this straight. Later on, we see a whole different picture where this July the 10th situation where there was a remediation of conditions in the property, and there was just a struggle to even get into the property. So some stuff deteriorates along the way. So this case becomes somewhat difficult because of the fact that there is some good, there's some bad. There's effort on one part, then there's effort on the other part. There's trying to do my best on one part, then there's trying to do my best on the other part. There's for lack of a better way of putting it to here, I'm pissed off at you, so I don't care what happens now. I'm gonna put up a roadblock and make sure that you can't get in, whatever. All of those things happened in this case. And so in drilling down on this case, yeah, I see where there was interference with habitability. I see where there was frustration with living there. The fact that there was mold that had to be remediated in more than one place. Those are significant issues in this case. One could even argue that the fact that there is a mold that could create breathing difficulties and what have you could be a basis to suspend rent altogether. And if we were sitting here today and the landowner never acted upon the mold, never spent the money that it took to remediate that condition, then this court's approach to this case would be clearly totally different than what I have to approach it now. I started out surmising without having all of the evidence in the case, but I started out surmising that this was the gathering of sort of a perfect storm, and that this was a nightmare of a situation for all parties involved. You know, when one person has to live in the property, it's a nightmare for them. When people own a property that they value, and they've got to figure out a way to spend $40,000. That's a nightmare for them too. It's a nightmare on both sides. Who has the worst nightmare? You all can flip a coin on that. I feel like if I'm living in that house, I got the worst nightmare. I feel like if I own that house and I got to spend $40,000, I got the worst nightmare. It depends on perspective. The outcome of this is what is horrendous, and that is that the lieutenant ultimately, in trying to grapple with this and work with this together with her mother, this ends up being a situation where she gets no further traction than she had perhaps when she began renting the property. Now, that's a little bit difficult to understand because she was able to withhold some $7,800 of rent. That should have been enough to begin to start to build a foundation. But I can't speak to how all of that went. I understand that some of that was put on buying sprays and cleanups and so on and so forth. She's testified that. I get all of that, and so I understand that is there. My determination in this case is that there is, to the extent that there is some damaged amount, that damaged amount is probably, after I consider everything that's here already, that damaged amount is probably in the nature of about $200 a month. And what that comes to is that really comes to about $2,600. My determination is, given all of the issues that were involved in this case, given the withholding of rent, given the valiant efforts, although not as quick as they perhaps could have been, but the amount of money spent in a period of about 12 months, $40,000. Even if I say, well, maybe it wasn't 40, it was 30, whatever. The testimony is that it was $40,000, but anywhere approaching those numbers, a lot of money was spent over that period of time. And it shows that there was really some effort to try to get this right. But it caused problems, and it caused problems to a tenant that was occupying the property. So my determination in this matter, in consideration of the damage to property that was suggested here, but more significantly was the the ability or the lack of ability to enjoy the premises in a reasonable state of repair for some period of time, the court would allow for an award that is tantamount to $200 a month over a 13-month period. And that will be $2,600. I'll grant judgment for the plaintiff in the amount of $2,600 together with the cost of a filing in this matter. That will be my order, and that will be my determination in this matter. I do wish all sides well, and good day.
Thank you, Your Honor. Now, will we get an order in the mill or?
Yeah, I was going to go ahead and fill out a judgment form now. Get that right to you. Ms. Starcher, do you recall what you straightened out with filing fees, ma'am, to file your case? Included in that was that the service fee for somebody to serve the complaint. Did you pay anybody to serve the complaint, ma'am? I'll do the mail. All right.
Your Honor, may I approach just to tell you something really quickly?
Yeah.